Thank you all for joining us today. As Danny said, I'm Ashley Strauss-Martin. I am General Counsel for the New Mexico Association of Realtors. It's funny because I hear all the time that I'm General Counsel for GAR or for LCAR or for the Santa Fe Association, various brokerages, specific brokers. I'm actually NAR's General Counsel. I've served in that capacity for going on 14 years now. So it's been my honor to do that. It's been a lot of fun. I've had a wonderful time working with the brokers. This is my disclaimer, guys. I'm not providing you with any legal advice today, and there's obviously no attorney-client relationship that's being created by this presentation. In the event that you want more legal information after this, there's information about the hotline that will come at the end of this presentation. If you need legal advice, you should seek that from your own independent counsel. All right, what are we going to cover today? Wow, lots of information. As Danny mentioned, the New Mexico Real Estate Commission has been busy. They have some rule changes that went into effect on the 1st of this, of the 3rd of this month. Home inspector licensing. I'm not going to cover those in great detail, but there are some key points that I want to mention. They did finish passing those rules, and those rules will become effective on the 15th of this month. I'm going to talk about the state legislative session, the 2021 session that's coming up. On the federal level, I'll talk briefly about the 2021 Appropriations Bill. I've talked to you guys about ADA website accessibility before, and I don't want to reiterate everything I've said before, but I do want to hit on some high notes. At NAR, antitrust lawsuits against NAR, kind of a status update on those. As Danny mentioned, Katie Johnson from NAR will actually be here for the board of directors meeting. I'm sure she'll talk to you about those as well. I'll give you an update here. The Department of Justice actually sued NAR, and they have already reached a settlement. So I'll discuss that and some changes to the Code of Ethics. NMAR forms, we have some significant changes to the purchase agreement, which is kind of one of our flagship forms, Form 2104, seller's property disclosure statement. We're going in a really different direction with that one, guys. So I'll be talking about that. I'm not going to cover the independent contractor agreement, but I wanted to mention it here just so that you guys know that we are updating it to kind of reflect some of these new changes that the Real Estate Commission has passed, because those changes impact that relationship between the independent contractor, associate broker, and the brokerage qualifying broker. I'm going to talk to you about some hotline topics and a little bit of case law, though there hasn't been a ton of litigation going on lately. That's actually a good thing. So let's get started because there's a lot to talk about. First, the New Mexico Real Estate Commission rules. They took effect on January 3rd. We have some changes to the definitions. In the definition of agent, the addition addresses commercial property managers. And I just want to say that I warn you a little bit about this language, because it says that in the case of a commercial property management, the property manager is an agent of the owner of the property for purposes of providing those obligations pursuant to a property management agreement, if the property management agreement specifically creates an agency relationship. And that language makes me just a little bit nervous, because it's one of those, if you talk like a duck and you walk like a duck, you're probably a duck, right? And so this is one of those, quack like a duck kind of things. Even if your property management agreement didn't specifically call you an agent, but you're doing everything that an agent would do, such as entering into contracts, lease agreements, these kind of things, then you're likely going to be considered an agent as far as the courts are concerned. So we have a new definition, but take that. I don't think anybody questions necessarily the fact that when we're working as property managers in the residential or the commercial context, we are working as agents of the owner in that capacity. A new definition for core elective course, and it explains that these are the kind of courses that improve your transactional experience, and they focus on, contractual and disclosure forms in the practice of real estate title issues, contracts. It might improve your business practices and professionalism, focusing on but not limited to broker responsibilities and duties. There are also courses that improve your broker awareness of issues that impact the public in real estate transactions, including land development, jurisdictional taxation issues, and it increased the broker's knowledge of third-party services within the transaction. So these are defined as your core elective courses, and those are important because, of course, you have to have so many core elective courses to meet your obligations under the rules. Then they also have a new definition for elective course. So they define those a little bit differently. And those are kind of a broader, less focused, less intensive course that focuses on real estate law and practice, real estate financing, mortgages and other financing techniques, materials specific to regulatory, technical, and ethical practices, and state and federal laws, including the ADA, fair housing, lead-based paint disclosure, things like that. It also includes these various other things, courses in personal and property protection for clients, broker skills related and offering to the use of computers, the internet, business calculators, other skills offerings related to broker professional development. So these are kind of the broader category that fall under these additional elective courses that they've now defined what those are. There's a new definition for property management, and really the interesting part about this is that, and the big part about this is the fact that it now includes management companies that manage HOAs. And that's been kind of a big deal because, as you guys know, under the HOA Act, there is no regulatory body that manages HOAs in any way, shape, or form. If there's a violation of that act, then the way that it's enforced is by somebody else in the association, bringing suit to enforce those provisions of the act. This particular definition now says that not homeowners associations specifically, they don't have to have a license to do their own business. But if they're going to contract with a third party, some third party who's going to take over the management, who's going to make arrangements for the common areas to be cleaned up, who are going to be collecting the dues and the fees from the homeowners, going to be preparing disclosure certificates and resale certificates, these type of things, they have to have a broker doing those things now, which is beneficial, I think, for the consumers, because in the event that these things don't get done or they don't get done properly, then there is some kind of recourse. You can, instead of having to bring suit to enforce it, you can actually contact the real estate commission and have a conversation with them about the fact that the broker is not performing the duties they're supposed to perform. So that's already taken effect, and that's going to be really something very new, especially for these big homeowner associations such as HomeCo and Canyon Gate and things like that. I know that some of them already have brokers that are working with them, others do not, and now they will be required to do so. We have a definition of residential real estate, as you can see here on the screen, a zone for private use as a living facility by the city or county, or designated by a city or county to allow for 4 or less family units on a single parcel. The term residential real estate is used throughout the Real Estate Commission rules in various contexts, talking about being able to qualify for your QB license. For example, you have to have so many residential transactions. There's also terminology in courses that they refer to. And now there's a definition of that residential real estate. The late renewal policy, that's now in effect. If you have to reinstate your license without outside of your 1-year period, and there's an exemption from the late fee penalty in the event that, that's within the 1-year period, because we talk about in a minute what happens after the 1-year period. But there is an exemption if you're late, you don't renew timely. If the reason that you're late is because of active duty military service or due to some impairment or illness or injury, that you can't complete the renewal requirements. And in these cases, the broker can make application. And there's a process by doing that. So they define what it means to be on active military or reserve duty. And they also define what it means to have a medically related impairment or incapacity that keeps you from actually timely renewing your license. And it also, I'll point out here in the medical related impairment, it also deals with your spouse or a member of your immediate family in the event that they fall under this category. And as a result, you've not been able to timely renew your license. You are going to have to provide some documentation to the Real Estate Commission explaining either the military issue or the impairment issue. And the Real Estate Commission will consider that documentation and decide whether or not you meet all of the requirements. And your license will be considered expired, and the broker may not practice real estate until the broker within the year from expiration renews, restates his license or her license. So again, you produce these documentation to the commission, and they will make a determination. And if you're exempted, then they will notify you that you've been exempted from the fees. And if it's not granted, the broker may still submit the late renewal, but be subject to the late fee penalty at the time of submission, that extra $270. And then this is the top part where it talks about renewal restatement after the period of 1 year from the date of license expiration, the broker will not be able to renew or restate their license, and the broker would have to undergo all the pre-licensure requirements to become licensed. So that's very important, you guys. I mean, it's like starting from scratch all over again if you don't get it renewed within 1 year after it's expired. So then we get on to new responsibilities for the qualifying broker. And there are quite a few of them, guys. So you're going to be very busy. I mean, these things are in effect right now. So you need to be working on doing these things. For example, developing a written policy manual about the duties and responsibilities of the ABs or the brokers in your office. It is supposed to be given to each of the brokers in your office, and they're supposed to read it. I mean, of course, you can't force them to do so, but the ABs are expected to read it, and they're supposed to sign that they've received it. It has to be available for inspection upon request by the commission. It has to include requirement for the AB to notify the QB of any situation in which the AB is unsure, untrained, or concerned. So anytime they're dealing with a situation that they don't know how to handle, there has to be provision in the written policy manual about how they need to, how to deal with that, and that they need to talk with the QB in that situation. It also needs to include a requirement to follow state and federal laws regarding real estate and the rules of the New Mexico Real Estate Commission. They now have also broken down the level of supervision that's required based on the number of years that the associate broker has. So in the event that they have less than 2 years of experience, then they need a higher level of supervision in the Real Estate Commission's opinion. And that makes sense, right? So they need to provide specific training and office policies for those brokers with less than 2 years experience. The QB needs to be reasonably available for consultation for the ABs so that they can make sure that they're not, violating office policies and procedures or local, state, federal laws, those kind of things. And if the QB has actual knowledge of a potential or actual violation relating to any of these things or a transaction that's occurring, then the QB must timely take action to correct or mitigate the potential or actual violations. They really need to step in. They need to be very proactive, especially with these brokers that have less than 2 years of experience. They have to respond. The QB has to respond to this broker within 24 hours of them having an issue or making a request, and provide assistance in preparing contracts, monitor their transactions from the time they go under contract till the time they close it, from A to Z, review documents in preparation for closing, ensure that the employing broker or an experienced licensee attends the closing or is available for assistance, and takes reasonable steps to ensure that the violations of statutes, rules, and other office policies don't occur. So you can see here, guys, that there's a lot more engagement between the QB and those associate brokers with less than 2 years of experience. And then they have another category for those brokers or ABs that have more than 2 years of experience. So the QB is still expected to engage maybe more than they've done before, but not quite to the same level as those new brokers or newer brokers. So you do still have to provide as a QB specific training and office policies and procedures. You have to be available to advise, correct, and instruct licensees to avoid violations of office policies and laws and things like that. If you have actual knowledge, again, of some kind of problems that's existing, right? So, or some potential problem that's coming up, you need to engage with your associate broker to try to mitigate mitigate the possible outcome of that by engaging and assisting. You have to maintain reasonable and timely communication with the licensees, take reasonable steps to ensure that violations of statutes and laws don't occur. And you may require review of all transaction documents. I will say in regards to this that these are additional. I will say that I know that some of the feedback that we've gotten or the commission got on this is the concern that, you guys are independent contractors as associate brokers. And so when qualifying brokers start really kind of trying to control what you do too much, obviously we've talked about in the past during these legal updates, how that can create problems from a wage and labor standpoint, because again, you're independent contractors. You will notice with these responsibilities and these obligations that have been created by the commission, most of them are simply making things available to the associate brokers and being available to the associate brokers. So it's not a matter of dictating you have to be at a particular meeting at a particular time, or you have to be at this particular session, these kind of things. Again, that can create some issues, and we've talked about that. But it's about making those things available and encouraging the brokers to attend those trainings or attend those meetings. The execution and maintenance of written independent contractor agreements is not a new rule, guys. And on this particular slide, the new information is in red. But I am going to be talking about that independent contractor agreement in a little bit, as far as why it's so important. And unfortunately, I've had to deal with a number of issues lately where when I receive the question and I say, well, what does your independent contractor agreement say about this? The feedback I'm getting is I don't have an independent contractor agreement, or I never received one. So I will emphasize again later when I speak about a particular issue, the importance of those independent contractor agreements. And I take a step back because I think I told you that this information in red is new. It's not new. I just am reiterating it because I get questions about it a lot on the hotline, and I think it's worth just a moment of speaking. So you are, of course, as a QB, required to receive and disperse all commissions that the broker is owed in a timely manner, and there's no specific time frame provided, but it's one of those things where you kind of know if it's timely or it's not timely. But this section in red talks about dispersing commissions to any entity entitled by law to receive the same, including the estate of a deceased broker, the deceased broker's surviving spouse, or any legally recognized entity wholly owned by the AB. So we're talking, LLCs or S corps that are wholly owned by the AB and their spouse. Those things can be money can be dispersed to those entities, as well as again to, for example, the estate or the spouse of a deceased broker who is in your office. So that comes up sometimes, and you do have the right as a QB to disperse to those persons and entities. There's some identification requirements. So you need to identify yourself under the QB responsibilities, identify yourself as a real estate broker on all phone calls, texts, or emails. And you have to disclose when buying, selling, or leasing real property on your own behalf that you hold a New Mexico real estate license. And we'll see that again when we talk about the advertising section of this in just a moment, and I'll address that just a little bit more in that section. There are some mitigating factors for qualifying brokers. So we've established all these things that you have to do as a qualifying broker now. And how can you mitigate your risk of being found in violation for not doing these things? And they have specified some things that you can do. So if the QB has implemented policies and procedures to prevent an AB from violating state or federal laws regarding real estate or rules, as demonstrated by the following: the written policies and procedures that we talked about, if you've created those and they're in place, and you also can demonstrate the AB has received training on written policies and procedures, made that available to the AB. Again, we can't make our associate brokers attend training necessarily, but we can certainly encourage them and make it completely available. And if you're doing these type of things, it's a way you can mitigate your responsibility as a qualifying broker in the event that something happens. Also, ongoing training and education of your ABs, ongoing discussions regarding real estate practices and procedures, ongoing discussions regarding completing real estate forms correctly, ongoing discussions regarding changes to forms, rules, and regulations. These are all ways that you as a QB, if you can demonstrate you've done these things, can mitigate your responsibility under the rules we talked about a minute ago. Any violation of the License Act by a licensee does not necessarily mean that the QB is going to be responsible, okay? It shall not automatically result in your suspension as a QB or your revocation of your QB license because your AB has failed in some way, unless the QB had actual knowledge of the act or rule violation. And when you have actual knowledge that there's a violation of the rule as a QB and you don't do anything about it, then that can create a situation for suspension or revocation of your license. The QB's failure to provide appropriate written company policy and procedures manual shall be cause for discipline, including suspension or revocation of the QB's license. So going back to about 4 slides ago, guys, where I said you have to have these policies and procedures in place and be talking to your ABs about them. If you don't have them in place, that can cause you to be disciplined as a QB, including suspension or revocation of your QB license. There are also some new responsibilities, obligations for associate brokers. So this isn't all falling on the QB. You as an associate broker have to notify your QB immediately and seek counsel of an attorney if necessary if you have questions or concerns about a transaction or process, including but not limited to violations of office policies and procedures, violations of local law, state law, federal law. You need to seek help with contract creation and completion when you're unsure, including consultation with an attorney if necessary. You need to ensure your own competence and knowledge of the profession by taking CE courses in areas where you are lacking skill or knowledge. So if you want to do work in the commercial realm, we know there's no special licensure for commercial work. You can do that at any time you decide to do it, but you wouldn't want to take that on without having taken some CE courses in commercial work, whether it be commercial leasing or commercial sales, or working with somebody who has experience in that area. So that's a responsibility of yours as an associate broker. And it says that you will not undertake assisting in areas which you're not trained. So going back to the commercial example, if you've never done a commercial deal in your life, you're not going to take that on without either working closely with somebody who has commercial experience or getting those CE credits and these kind of things under your belt. And, even with education, I mean, education is wonderful, but it doesn't actually give you all the time a feel for how an actual transaction goes or issues that should arise during a particular transaction. So I think even if you're taking CE credits, if you're entering into an area of real estate with which you're not familiar, always a good idea to associate with somebody initially who knows that area of real estate. You need to read and understand and follow policy and procedures manuals that have been provided by the QB. Disclose when buying, selling, or leasing that you have a real estate broker's license, and identify yourself as a real estate broker on phone calls, texts, or emails. You have an obligation as an associate broker to renew your license timely and take all of your continuing education courses in order to renew your license, and to notify your QB immediately if the license cannot be renewed or has expired. You also have an obligation now, guys, to submit all advertising not prepared by the brokerage to the QB for review and approval before you release it. That's very important. I don't know how many guys are doing that as it is, or how many office policies provide for that as things stand, but all advertising has to run through the brokerage. So we're going to assume when you see an advertisement out there that the brokerage has signed off on that, and that is acceptable to the brokerage, because that's now an obligation of the AB to submit it and an obligation of the QB to review it. Unless the QB or the brokerage has actually created it. We have a couple of changes to broker duty disclosure. So we had this language, other written agreement, that showed up in the broker duty disclosure about, 3 years ago, and we never really knew what it meant. We didn't have a real clear understanding of what it meant. We did talk about it in the context of referral fees. If you have a referral fee in an agreement, does that require you to disclose that to your customer or client? We talked about various types of agreements that might fall under that, but we never had any really clear direction on that. They've now taken the words "or any other written agreement" out of the broker duties, so that's no longer even a requirement we have to worry about. They also added in the language at the bottom here in yellow: the broker shall disclose the existence of such agreement in writing to other brokers involved in the transaction. The language right above that explains that as a broker, you have to actively participate in assisting your client to get to the closing table, right? So you're helping them comply with the terms of the agreement. But there are brokers out there, sometimes we refer to them as limited service brokers, that enter into agreements with the customer or client that specifically says, I'm not going to be performing those duties. I'm not going to be assisting you to get to the closing table. I'm doing something very limited in this relationship that we have. And in the contract that broker has with their customer or client specifically calls out things that will not be done or the things that will be done and amends our listing agreement. And right now we don't have I get calls about that every once in a while. Do we have something like that in our library, a limited service type listing agreement? And we do not. But these brokers that work in that arena do have those type of listing agreements in place. And it specifically says what they will not be, the duties they will not be performing or the obligations they will not be meeting for the consumer. This provision in yellow here, it used to be in there. It disappeared in one of the reiterations of the broker duties, and now it's back again. In the event that you are working as a limited service broker, you now have an obligation to disclose the existence of such agreement in writing to other brokers involved in the transaction. So, for example, in the MLS, and you often will see that as it stands now, you'll often see something that's in the MLS that says that the buyer's broker should be contacting the seller directly on this one, and it gives you an understanding that it's a limited service type situation. But explicit disclosure to other brokers that you are only working in a limited capacity for the seller is required now. Again. CE requirements. So the AB CE requirements are still 36 hours, but the QB CE requirements have increased to 42 hours of CE courses approved by the Real Estate Commission during each licensing cycle. And for each licensing cycle, you have to take the following. The 4-hour core course, as you guys all know, has to be completed annually. So you have to do that 3 times during your 3-year licensing cycle. For ABs, you have 4 hours of core elective courses to be completed during the 3-year cycle. For QBs, you have 8 hours of core elective courses to be completed during the 3-year cycle. QBs, 42, you're taking those 42 hours, and 6 of those have to be your QB refresher course. So those 6 hours are included in your 42 hours that you have to take. 4 hours of ethics. And then, of course, if you're doing property management, then you're going to have to do additional CE requirements that are specific to property management. All your remaining hours may be earned towards CE renewal requirement from approved courses by the commission, non-core elective category courses, which we talked about, additional core elective category courses, which we talked about, and or ethics category courses. So as I said before, we have definitions now of this non-core elective and core elective and what kind of topics will fall under those categories. And you can take the rest of your hours in those categories. If a broker fails to complete an annual core course required for the first and or second year of their 3-year licensing renewal and is unable to complete a makeup of the missed courses with an approved core instructor prior to license expiration, the broker will be required to successfully complete a 30-hour broker basic course prior to expiration or as a condition of expired license renewal reinstatement. You will get credit for the renewal purpose, but you will not be given any continuing education credit. So you're going to have to take this 30-hour broker basic again, guys. So it's very important that you take these courses yearly, but in the event you don't take your core course on 1 year, and you realize that when you go to renew your license, you can find an instructor to teach you that course that you missed. If you can, then you can avoid this requirement of this 30-hour broker basic course. And if you can't, then this is the situation you find yourself in, taking this 30-hour broker basic course for no credit, continuing education credit. So if you broker fails to complete any one of the core course requirements within the context of the year cycle due to medical reasons, they have created some exceptions to this, also for military deployment. So it's kind of something similar to the license renewal. In the event that you can prove that the reason you weren't able to do it is because you were deployed or because you had some medical reason that prevented you from doing so, then you can actually get an opportunity to make that up. And they will require documentation, again, doctor's affidavit or letter, things like that, in order to make sure that you actually did qualify for this exception. And the continuing education course hours generally carried forward to the next. This is important because you didn't used to be able to carry anything forward, but what they're saying is if you take a core course, an excess of 12-hour course normally sufficient for the cycle. So if the broker renews their license early within their online renewal 2-month period, and they meet that 36-hour minimum or 42-hour minimum, depending if you're a QB or you're an AB, and then the broker takes a core course between the date of the renewal and the end of the cycle's date of expiration, they will allow you to take that core course and move it into your next licensing period. Okay, you can carry that forth for the next year. So they made an exception to those kind of carryovers that are allowed. And this is the exception. It has to do with the core course and the ability to move that to your next licensing cycle in the event you should take it in that window. There's a whole section now, guys, on volunteer service and getting CE credit for being a volunteer at the Real Estate Commission. And we know that's a terribly time-consuming endeavor, right? Whether you're working as a commissioner or sitting on the advisory committee, or you're doing, some kind of special task force that's been put together. In any of those scenarios, it can be very time-consuming. And so the commission recognizes that, and they are providing for CE credits in the event that you should be part of any of those type things, the commission, the advisory committee, or one of those boards. So you can get up to a maximum of 16 hours during a 3-year licensing cycle as a commissioner. If you're sitting on the education advisory committee, you can get a maximum of 16 non-core elective credits in a 3-year licensing cycle. If you're appointed as to the residential management advisory committee, again, 16 non-core elective credits. And if you are appointed to a term as a member on any other real estate commissioner task force, you can get up to 16 during that period of time as well. So it encourages, I think it really encourages everybody to volunteer, right? I mean, you get CE credits now for doing so. So that's wonderful. And the recognition of the work that you've put in for the commission. The real estate advertising rule has changed only slightly to provide that you now have to disclose the fact that you are a real estate broker in the event that you are buying a piece of property, or you and we talked about before in the requirements of QBs and ABs if you're leasing a piece of property. So this provision is new because it used to be that in the event you're selling, the rule says that you have to advertise the fact that you are a broker on your signs and also include that in your contracts if you're selling a piece of property of your own. And it never talked about buying on the other side of the transaction, whether that disclosure was required, but now it is. So you need to include the fact that you are a licensed real estate broker if you're buying or leasing property going forward. Commission will conduct a background check to non applications. I think we're aware of that, including renewal applications, and they may use that information in determining the applicant's eligibility for licensure or renewal. So they will be double checking on those background checks and making sure nothing's occurred since last time you guys had a background check. And in the event that something should come up, it could affect the renewal status. Okay, let's talk about home inspector licensing a little bit. I'm not going into a tremendous detail about this, but I do want to just touch on it briefly. They did pass the rule, so the board was convened and they did go through the rulemaking process, and that was published in the federal and the state register last month. And the rules do take effect on January 15th, but that doesn't necessarily mean everybody has to be licensed by the 15th. There are some home inspector licensing rules, or I should say law, that's in place now. This actually came out of the act, not the rules. And I talked about this briefly at my last session, but I wanted you guys to remember that this is already in effect right now. There does have to be a pre-inspection agreement with the client. That talks about the amount of compensation, the list of components and systems that will be inspected, when the client's going to get the report based on when the inspection is done. And if there's no date by which they have to get the report, then it's going to be due within 5 days after the inspection. It must include this exact language, and this exact language is also going to be in the final report. And this is the exact language. And this is important for everybody to understand, including the consumers, that the home inspector will not determine, and the report provided upon completion of the home inspection will not contain a determination of whether the home or components or the systems of the home that have been inspected conform to the local or state building code requirements. So they're not going to be checking for code, guys. That's not their job. They're not even permitted to do it under the law. And they're telling the consumer that not just in the final report, but also in the pre-inspection report that has to be provided. The rules that were passed recently deals with these type of things: fees and disciplinary proceedings, insurance, the code of ethics, and they do have insurance. They are required to have insurance. We talked about that before, and that's great news. They should have already, and I think most of them did, but some of them did not. They do have to have insurance now. Continuing education, renewals, and reactivations. This is all covered in the rules. I wanted to point out that even though these rules take effect on July 15th, obviously, they've just created rules for what kind of testing has to be done. And those people haven't taken the test yet. They haven't had an opportunity. So that starts on the 15th, the requirement to start getting those things done. And what they've said is that within 6 months of the effective date, which will take us to mid-July, right, July 15th, everybody should have a license by July 15th. And that July 15th deadline for everybody to be licensed, that gives them plenty of opportunity to take the required testing and fill out the applications and do what they have to do. That may be extended in the event we have some kind of, the pandemic has created a lot of interesting issues over the last year. And if there's some kind of emergency that occurs that requires an extension of that July 15th deadline, the board has the power to extend that July 15th deadline. But right now, that's the date that we're working with. But nothing in the rules permit any person engaged in the practice of home inspection, whether licensed or unlicensed, to violate the code of ethics or standards of conduct as adopted by the board. It's one of the rules that they have adopted, and it does not permit such person to violate any aspect of the Home Inspector Licensing Act. So you're going to see inspectors getting a bit very busy over the next 6 months, obtaining their licensure, getting their insurances in place if they don't already have that, meeting the other requirements that have been set forth by the law and by the act and by the regulations. I wanted to just point out this one particular aspect of the law because it you guys are specifically mentioned in there. You're called realty agents here, which never heard that term before, really, with you guys, but that's how they're referring to you. So it talks about conflicts of interest, and a home inspector shall not, evaluate, inspect a property for compensation in which they have or expect to have a financial interest. So if they own a property, they can't conduct the inspection on it. Inspect a property under a contingent arrangement whereby any compensation or future referral is dependent on reported findings or on the sale of the property. Direct or indirectly compensate realty agents or other parties having a financial interest in closing or settlement of the real estate transaction for the referral of inspections or for inclusion on a list of recommended inspectors, preferred providers, or similar arrangements. So I think that's pretty clear, guys. The home inspector cannot provide you with any kind of compensation, directly or indirectly, to either have you refer business to them or to get on a list that you give to your customers and clients. They cannot receive compensation for an inspection from more than one party unless the client consents in writing to the compensation arrangement. They can't accept compensation directly or indirectly for recommending contractors, services, or products to a client or other parties having an interest in an inspected property. So they can't do an inspection on a property, for example, find things that are wrong with it, refer the consumer to some contractor to get those things fixed, and then get some kind of referral fee or compensation from that contractor for that referral. They can't perform or offer to perform for an additional fee any repair to a structure on which the home inspector or home inspector's company has prepared a report at any time during the 12 months immediately prior to the repair or offer to repair. So in the event that the home inspector also does repairs themselves on properties, they can't do that repair if they've done a home inspection during the 12 months immediately prior. So there's going to be a session that I just learned about this. So thank you, for, Jeff Gorham. He's a home inspector down in Las Cruces, informed me that on January 22nd from 9 to 11, GAR will be hosting a virtual session on the Act and the new rules, and that it can be viewed statewide. I've talked to Steve about it, and we weren't aware of it as well, but we're going to make sure that we get that information out to all of our members. You might want to tune in and watch that and learn more details about the home inspector licensing rules and the Act and the implementation of those over the next 6 months. The license applications will be available on the Home Inspector Board's website on January 15th. So while you won't be looking for licensed home inspectors tomorrow or on the 15th when these rules take effect, you will be seeing inspectors getting their licensures in place over the next 6 months. And again, unless there's some extension based on some emergency that occurs, by the 15th of July, we should see all of our home inspectors who are doing home inspections should be licensed at that point. So that's kind of the plan, but you'll get a lot more information on January 22nd, if you're able to tune in to that particular presentation. And again, GAR, I'm sure, is sending something out on that to its members, but in light of the fact that it can be watched statewide, we as a state association will make sure that our members statewide get that information and can tune in. Okay, the legislative session 2021. We are proposing some changes to the Real Estate Disclosure Act, specifically dealing with the estimated property tax disclosure. I will mention that down in Albuquerque, which is not specifically related to this, but there is the county assessor's website and there's the treasurer's website. And one of the websites lacks a component of the required estimated property tax disclosure, and that's the current property taxes on the property. It gives the estimate, but it doesn't give the current. And so that website is probably not the best one to use. And I believe it's that might be the assessor's website and it's the treasurer's website that should be used. But I think we've covered that in the past, and I can get that information out to you. But I just wanted to let you know that there was a component of this estimated property tax disclosure that requires the current taxes to be disclosed as well. And so you need to make sure if you're down in that area and whatever area you're in, that your assessor's estimated property tax disclosure that they are making available through their website includes that information as well, not just the current one along with the estimated property tax disclosure. So take a look at those if you haven't done so. So the changes that we are proposing have to do with the definition of residential property, or in this case, there is no definition of residential property under the estimated property tax disclosure law. So as you guys know, the whole reason that this law came into effect back in 2009 is because when you own a property, residential property, your taxes can go up no more than 3% per year. So there's a cap on how much your taxes can go up. Mine seem to go up exactly 3% every year by coincidence. It's supposed to only go up current and correct, right? They're supposed to tax it current and correct. So if your property hasn't actually increased in value by 3%, then they shouldn't be going up 3%. But nonetheless, I think that traditionally we're seeing pretty much 3% increases every year. But the reason that we created the law is because you have the benefit of that cap as long as you live in the property. But as soon as you transfer the property, as soon as you sell the property, that cap just disappears, right? So we no longer have that cap in place. And if you have people that have lived in a property for a really long time and have just gone up a little bit, 3% every year or something less than that, then when they go to sell their property, if the values have increased incredibly, and that's what was happening actually back in 2009, or even a little bit before that, then what you see is a tremendous jump in the property tax that the buyer will be paying on the property versus what the seller was paying on the property. And that could very well impact the buyer's ability to afford the new home. And so that's how this law kind of came about. But the problem is that in this particular law, which is not found in the taxation section of the statutes, it's a whole different section. It's in the property law section. We don't define what residential. So we don't know. And at the beginning, when this law first came out, Tax and Rev took the position that residential was 1 to 4 family dwellings, and that was it. But somewhere along the line, they realized, hey, we really don't have any basis for saying that's the definition of residential, and we need to find a basis. And so they went back to using the definition of residential from the property tax code, a whole different section of the act. And that was a very different definition than the 1 to 4. It really kind of opened that up. And it included now sellers of large apartment complexes who were now bound by the disclosure requirements. It also included people that were ranches, big ranch pieces of property that did have a dwelling on them. And that's problematic for reasons I'll discuss in just a minute. But as far as the large commercial properties, such as the apartment complexes and things like this that were now in there, they were never the intended, should I say, the buyers were never the intended beneficiary of this act. They weren't concerned about protecting commercial buyers buying these large commercial complexes. They were concerned about protecting kind of the people that were buying homes, and that's the basis of the act. So the fact that somehow these big commercial complexes got in there was kind of accidental, because again, we had no definition of residential, and so now we're using a definition that incorporates them. So we are creating a new definition of residential that actually excludes the commercial type properties, and we limit it to the 1 to 4 family dwellings. And then we also exclude things like ranches or other residential type properties that will that the estimated property tax will not be a fair amount or reflect a fair amount or the accurate amount of taxes that particular buyer would have to pay. So when you're dealing with ranches or big pieces of property that fall into one of these special evaluations, whether it be livestock or minerals or things like even manufactured homes, when they're not permanently affixed to the foundation. If you go and get an estimated property tax disclosure based on just the list price, which is how this Real Estate Disclosure Act works, you're going to be completely off from what the buyer will actually be paying in taxes, because these special methods of evaluation that are implemented in those type of properties. So, I think it's worse than not giving them anything, because you're actually giving them information that's completely off base and not accurate at all, leading them to believe that they will be paying something that could be, significantly lower than what they actually will be paying. So what we want to do is try to carve those out of the definition of residential. And so that's what we've done here: 1 to 4 family dwellings, real property, and we define what dwellings are, but we do exclude all of these properties that have special valuations under these particular sections of the law. The other thing that we're doing in the same exact section is trying to deal with the disclosure issues that are inevitably going to arise in the event that the cannabis bill passes. So as you guys know, again, because it's been, I think, I don't know, one or maybe even two sessions, that there has been a bill introduced to legalize recreational cannabis or marijuana, right? In the event, and it, you know, it looks pretty good actually, that might get passed during this next legislative session. And if that should happen, then the question I know that I'm going to get on the hotline is if a place, because I get it already and we're just dealing with medical marijuana right now. So as soon as recreational comes on the market, that's going to impact a whole lot more properties. And the question is going to come up a whole lot more often. Do I have to disclose the fact that this property was used for cannabis production? And it's amazing that a lot of the states don't address that issue in their laws. But you know, I feel like we need to address the issue, again, mainly because I'm going to get the question, but also just because of some studies that have been done. As you can see here, the U.S. Drug Enforcement Agency's recent report on residential marijuana grows in Colorado said, I mean, the title of the article was "The New Meth Houses?" ? It describes how the legalization of marijuana in Colorado has led to the proliferation of indoor marijuana grow operations in hundreds of homes throughout the state. And the report notes that marijuana grows often cause extensive damage to houses where they are maintained. And much like the meth houses of the 90s, many of these homes will ultimately be rendered uninhabitable. That's pretty big, right? I mean, that's pretty big. And so if there's data out there that indicates that this is what's going on, I think that it's going to be hard to say that the fact that it was used as a grow house is not an adverse material fact that has to be disclosed. I think that's going to be a hard argument to make based on those findings. But with that said, if we don't create clarity, then there is no clarity in the law, real clarity until it gets litigated. Unfortunately, the courts are kind enough to provide us clarity on occasion, but we'd rather have some clarity before it gets to a court, up to the appellate court where we have some case law. So we've created some law within this Real Estate Disclosure Act that talks about required disclosure in the event that something has been used as a grow house. And the proposal that we're talking about, and we're going to be talking about this more at our legislative committee at the end of the month, kind of fine tuning this, is in the event that there is actual knowledge that the building was used for cannabis, actual knowledge that it has to be disclosed to a potential buyer. And the method of disclosing, or the process, is something similar to estimated property tax disclosure. So, you know, the seller and the listing broker know about it. They disclose it to the buyer's broker. The buyer's broker discloses it to the buyer. The buyer signs off that they received the disclosure. And it's kind of the same process that we had before. So, we might fine tune this. Like I said, the legislative committee is going to have a conversation about it at the end of the month. But in the event, and of course, if the Cannabis Regulation Act doesn't occur, if it doesn't pass, then this is going to be unnecessary. I don't necessarily think we need to mess with this as far as the medical marijuana is, even though the question comes up, it doesn't come up often enough necessarily for us to need a legislative change to this particular disclosure act. But if the Cannabis Regulation Act does pass, we do need some clarity on what the required disclosure is. And we're able to limit liability here, guys, because we can say you actually have actual knowledge that the building was used, right? So it's not, I heard from a friend who heard from a friend who heard from a friend that it used to be a grow house. No, it's actual knowledge that the building was used for cannabis production. So like I said, we might be fine tuning that at the end of the month, but in the event that the Cannabis Regulation Act moves forward, we'll probably move forward with something along these lines. Remote online notaries. So what remote online notaries are, for those of you who don't know, it's when, for example, I'm sitting here and I'm a notary and you are where you are and I'm watching you on a screen and we're talking on a screen and I'm watching you sign, and then I stamp it and say that I watched you sign it. That is a remote online notary. And boy, we could have really used that during this pandemic, right? I mean, it's come up a number of times. And the governor at the beginning of this pandemic actually passed an executive order to allow for remote online notaries. But the problem is that there are legal issues involved with accepting filings at the county clerk's office, a notary that has been done so online. And the county clerk's attorney issued a memorandum to the county clerks throughout the state that basically said, enumerated all of these problems and showed real title issues going forward if they accepted anything that had been had used a remote online notary. And so as a result, the county stopped accepting them. I think in the beginning there were some that were accepting them, and then I think most of them, if not all of them, have stopped accepting them. So we are working with the Land and Title Association and the county clerk's office on a bill that would make it possible to do remote online notaries. The other issue that we had with online notaries had to do with lenders, federal, at the national lenders. But there is federal legislation moving forward that will also address that issue. So we anticipate being able to do remote online notaries maybe after, assuming this gets through in the next session by summer or early, that's usually when those, if a bill passes in January, it usually becomes effective in, I think, June. So we should have those in place by that time and be in a place to do remote online notaries, which will be terribly helpful in light of the pandemic situation. But right now, you're probably not seeing any counties that are accepting those. And like I said, the rationale or the reasons were set forth in a memo that the county clerk's office attorney for all of the counties throughout the state had submitted to each of the individual counties explaining the problems with accepting those. So for right now, you still got to do in-person notaries. I just will mention, I'm not going into great detail about the Uniform Owner Resident Relations Act, but I did want to mention that there is a group, I think it's the Center on Law and Poverty, that has introduced a bill that is changing the uniform, proposes to change the Uniform Owner Resident Relations Act, which of course is the act that governs landlord-tenant relations in New Mexico. And they're really trying to increase protections for tenants. That is their whole goal, is to protect the tenants. And they are really proposing a lot of language that would be onerous and make it more difficult for evictions and give tenants more time to pay rent if they're late, and before a landlord can actually take action, allow for an appellate type situation if there is a writ issue to evict them that would allow them to appeal and give them some more rights there. So it's very much pro-tenant, and we are working closely with our property managers who are members of our association, and also the local chapter of the National Association for Residential Property Management. They've been putting together some real great information, and I think a video on how this will impact the industry. And I think their intent is to send it over to the legislators and have, so that they understand the other side of this, because it will have a tremendous impact on owners and landlords. So we'll be working with them on that and addressing those issues as they develop. Legalization of recreational cannabis. As I mentioned a minute ago, this is again up for discussion at the next legislative session. And the bill has been introduced, and it has been massaged quite a bit by various parties that are interested in it. And it very well could pass during this next session. I'm not going to go into the details of the bill. Again, it allows for the production of recreational marijuana and sale of marijuana. And I'm not going to go into the details because it's a huge bill and it would take us all day just to get through that. But there were some interesting statistics, and I did want to introduce you to a document that the National Association had put together that has some really great stats on the legalization of marijuana. As you can see from this map, there's a number of them that have recreational and medical was legalized before 16, Colorado, Oregon, Washington. And then there's the green ones are the recreational medical legalized since 16. So there's a handful of those. And then only medical, all of the blue you see here on will allow for medical use, which of course New Mexico is among those. And then there are still a number of states where whether it be medical or whether it be recreational, it's still illegal. At the federal level, it's still considered an illegal substance. But I think that they're looking at federal law to change that as well. But this is the document that the National Association put out that gives you a whole lot of great stats on medical marijuana. And if you pull this presentation off of the website, then you can click on this link. Otherwise, you can just type it all in. That's a really long link, I know, guys. But if you pull this off of the website, you can just click on it, and it'll take you to this publication that the National Association put out in 2020. And so you might want to read about that. A lot of interesting things. Like I said, I'm not going to go into tremendous detail or any detail for that matter on the proposed bill here, because there's just a lot of, it's tremendously detailed and we just don't have time today. But if you're interested in it, I'm happy to send you a copy of it and you can read it at your leisure. The other thing that we're doing during this next legislative session is we are revising or proposing to revise the Condo Act to bring it back in line, to bring it in line with the HOA Act. So the HOA Act has gone through quite a lot of changes. First it was introduced and then it went through some changes that since it's been introduced. The Condo Act hasn't been touched in years. And so now we think it would make sense for these two acts in some respects to be more aligned. So one of the things we're dealing with in the changes deal with governance, financial audits and budget, meetings, officer and director's duties, dispute resolution. But the part that's important for you guys deals with the protection for buyers, right? And so this is a section that talks about how, first of all, buyers or homeowners, people that live in homeowners associations can have access to all of the records, that they have to make those available. They have to make them available for free. If they want to have copies, if as a homeowner in an association, you want a copy of it, then you can get that for 10 cents a page. This is all, again, the same kind of language that we see in the HOA Acts. There's a definition of, or the HOA Act, there's a definition of financial and other records in this section that the homeowners are entitled to. And then it talks about how if you fail as a homeowners association to provide these documents within 10 days after receipt, it creates a rebuttable presumption that the association is willfully failing to comply with the act. And if they're denied access altogether, a homeowner or a condo owner is denied access altogether, then there are fees associated with penalties associated with not allowing the condo owner to review these records and other financial documents. Both the disclosure statement, which is the one that the developer has to provide, and the resale certificate, which is, again, reselling. So it's the one that the seller has to provide in the event of resale. We created some language similar to what we have in the HOA Act that caps that resale certificate at $300 and also caps any updates to that for key information. For example, what the condo owner may owe at any given time. If that information has to be updated because the closing goes beyond 30 days or 60 days, then they want an update of that information. That can be requested, and there's a cap on how much they can charge for that, the $50. The other thing I did in this Condo Act, because we continue to see this to be problematic with HOAs, and I get this call all the time, guys, on the hotline. So we have a resale, a disclosure certificate, and there are all these items or elements of that disclosure certificate, and those are dictated by law, what has to be in there. And then when you know it, the title company or the lender, they request one more piece of information, just one more piece of information that you don't see in this disclosure certificate. And all of a sudden, a new fee shows up on the closing statement from the HOA company saying, well, this is a different piece of information. And so that allows them to circumvent the $300 cap. Because it's a piece of information that's not on the list of things that are in a disclosure certificate. So the language that I'm proposing for the Condo Act is all of those items that are already in the disclosure certificate or the resale certificate. And there were a couple of things we added to the resale certificate that we have in the disclosure certificate under the HOA Act. But in addition to that, any other information or documentation required by the title and or mortgage company for the sale, closing, and or funding of the unit. So in other words, in the event you have to request additional one piece of information, it's going to fall under that disclosure, that resale certificate cap of $300, and there can't be an additional charge. I made some attempt to get this done when we were working on the HOA Act and met with a lot of resistance from the big management companies, mostly not our folks. We didn't have any trouble with our folks or the self-managed HOAs, but the big management companies were resistant. But we can make another run at it, and if we're successful, then that would at some point maybe require us to go back and see if we can make that same change to the HOA Act again. Again, one more piece of information shouldn't cost another $200 or $300, but that's what we're seeing. So those are changes to the Condo Act. The other thing that we did for the protection of buyers in the HOA Act that we've included now in the Condo Act is that anytime the HOA has, when they have fees that they're going to charge their homeowners, and here in this case, the condo owners, or the management company is going to charge the homeowners, or in this case, the condo owners, the management company and or the board is required to provide a list of those fees on an annual basis to the members of the association. So every year when they're sending out their financial reports, they have to also include, hey, if you need anything from us or from our management company, this is what you're going to get charged. These are the fees, all the fees that are going to be charged. The idea when we first created this particular requirement was that if the homeowners within the association were aware of the charges that they were going to be hit with, for example, when they went to sell their property and needed a disclosure certificate, that they would be proactive before they went to sell their property in getting those fees, negotiating those fees, whether it be with the board itself or whether it be, and more often than not, with the management companies. So if they knew in advance, long before they were going to sell, hey, when I get ready to sell, I'm going to pay X number of dollars for this disclosure certificate, they could be having that conversation with the board, who could be having those conversations with the management companies before that seller went to sell. Is that a reasonable amount to be charging? So now, full disclosure of all those fees that could possibly be charged. Before we get into federal issues, guys, I don't have a clock, so I could just be talking here all day. But I think now it's time for a short break, 10 to 15 minutes at the most, so that we can get back. Oh, okay. All right. I did have a sign earlier, but evidently I do have time to continue talking because it's only 10. All right, great. I should get a watch, shouldn't I? Where's my phone? So we'll just keep moving forward for about another 30 minutes, and then we'll take a break. So let's talk about federal issues. There's only a couple that I wanted to talk about. Appropriations, the 2021 bill. This does really impact landlords tremendously, because landlords can now apply for help for their tenants. So even if their tenants aren't applying for their own help to help pay their rent, because they're not all that concerned, because they can't be kicked out right now because there's moratoriums on that, the landlord can step in and actually apply for help for their tenants to try to get some of that rent paid. So that's good news for landlords. It can cover back rent for up to 3 months, 3 months back. The CDC eviction moratorium, as you guys know, talking about the evictions, actually was extended through the end of January. So it was supposed to expire the end of December, but it's now been extended. I'm going to talk about that a little bit more in a few minutes, because when we get to some hotline issues, because it keeps coming up. Carbon monoxide detectors required for federal housing. There are allocations of 284. Oh my goodness gracious! Look at that number, 284.45 billion for loans for eligible businesses, which are 300 employees or fewer, and a decline in gross receipts of 25% or more in 2020 versus comparable quarter in 19. I'm not sure that, impacts our salespeople out there or brokerages out there. We've had a really banner year. We've been tremendously blessed and lucky in that respect. It was a really great year for real estate. It also extends the PPP covered period deadline to September 30th. It allows you to deduct expenses paid with PPP funds. It also gives up to $600 a person in stimulus payments. We've seen that before, right? And they start to phase out at $75,000 for individuals and $112,500 for heads of household and $150 for married couples filing jointly. Price for an extension of pandemic unemployment assistance through March 14th, 2021. So these are just a couple of the highlights of this bill. The other thing I wanted to talk about briefly, and I've talked about this before too, and I know you guys thinking, oh gosh, please don't talk about ADA compliant websites again, Ashley. It's not exciting stuff. And I recognize that it is so much easier said than done. I don't know how many of you guys went out there after my last presentation and actually looked into trying to get their websites compliant. But like I said, it's much easier said than it is done. So as we talked about, the ADA says that your websites are places of public accommodations. And in the event that they can't be accessed by people that have disabilities, then there are remedies available to those people. And they're private remedies, so civil lawsuits can be filed against you. They can ask for injunctive relief, meaning take down your website until it's ADA compliant. They can ask for attorney fees, cost. The DOJ can come after you, penalties ranging from 75 to 150. Again, injunctive relief and damages. The guidelines that they're using to determine if a website is ADA compliant is this Web Content Accessibility Guidelines. It was published by a private group of experts in 2018, because we have no law that specifically says these are the things you have to do to make your website compliant. But they are relying, the DOJ and their settlements and in going after people are relying on this Web Content Accessibility Guidelines. Lawsuits, and this is why I'm bringing it up yet again, because you can see that the number of lawsuits has increased significantly from 2017 to 2019 on this website accessibility issue. And if you look here, you can see what states, knock on wood, New Mexico is not one of them at this time, but you can see that New York and Florida were really hit hard. And I will say that during a recent presentation that I did with the National Association of Realtors, the Florida Council, my counterpart in Florida, came on and spoke to the fact that I think, if not all of these lawsuits, most of these lawsuits that were filed in Florida were filed against real estate brokerages and brokers. And so that state association was being inundated with calls from their brokers saying, I just got served, I just got served, I just got served. It was obviously some plaintiff's attorney down there really targeted the brokers in that regard. And it was a very difficult time. And of course, the state really rallied to assist in dealing with those. And I think most of them were settled. I think most of them do get settled. But nonetheless, guys, this is real, and we need to be working towards a solution to the extent that we can. So what does it mean to be accessible? It means that, you have something available for blind. So the blind people, so screen readers and alternative text for images, properly labeled form fields, people with low vision, color contrast, text resizing. If people are deaf or hard of hearing, there's captions for audio content, mobility, keyboard only accessibility to slow down or turn off timeouts, epilepsy, no flashing content or a lot of moving content. If you're colorblind, color should not be used as a sole method of conveying information. So these are ways, things that you have to be cognizant of when you're talking about making your website ADA compliant. There are ways that you can self-remediate. So you can go in there and you can and you can look at some of the things that I identify here and say, oh yeah, well this is happening and this is happening and this is happening. You can also outsource your solutions. I just warn you that if you see some really cheap solution that probably is not going to work, at least not to fix the problems, maybe to identify the problems. And there's various ways you can identify problems. Like I said, you can go in and look for them yourself. There are also some web programs, some software you can buy that will run in kind of a check of it and then identify all of the issues. And then you can start either working on those yourself, or you can hire somebody to work on them for you. Other ways that you can avoid some issues with this is requiring on your website, having a provision that requires arbitration of all claims in your terms of use. If you have a terms of use section of your website, arbitrating these matters, opposed to, because if they say, if you're going to use my website, you're going to agree to these terms say you have to arbitrate, opposed to litigate, you're not likely to get a lawsuit filed against you, or even necessarily a demand letter. I can't promise you anything, but if you have that in there, that can mitigate that possibility. 24/7 telephone line, providing full service, accessibility statement, policy and procedures on making your website accessible to persons with disabilities. Vendor contracts, third-party content and training. These are all ways that you can kind of strategize or ways to avoid or defend your lawsuits in the event that one should come up. So I encourage you guys to look into and research. And the other thing I encourage you to do is to share your knowledge, guys, on this, because I've made some calls and I've made some inquiry on this, and I know it's not easy and it's not inexpensive. I mean, one website can cost you several $1,000s to get it ADA compliant. So, they may run the diagnostic for you for free. And then when they identify all of the issues and have to go in and change your website to accommodate, that's the point at which they start charging serious money, and it can cost you several $1,000s for one website to be fixed, so to speak, to make it ADA compliant. So I encourage you guys to share information amongst yourselves and with me, so I can get it out to members. If you find a great solution, you find a great company that will identify issues, a great company to fix issues, these kind of things. So we all, I think, need to continue to work together, because I don't think this is going away anytime soon. Okay, topics: antitrust lawsuit, DOJ lawsuit, and code of ethics. These are things happening at the national level that I'd like to talk about. Antitrust lawsuits. As you guys know, quite a while ago, there has been actually more than one kind of class action lawsuit filed against the National Association of Realtors, all surrounding antitrust issues. That's what this is all about, guys. And it really focuses on the MLS and the offer of compensation that the co-op broker makes in the MLS. And in these lawsuits, which I've talked about in great detail in the past, and I think that, again, Katie will be talking about it at our board of directors meeting, NAR did file a motion to dismiss. And the motion to dismiss is filed very early in the litigation. And it's when a party believes that the complaint is invalid, right? Even if you assume everything in the complaint is absolutely true, they have failed to state a claim that there's any recourse for, right? It's completely invalid, even if you assume it's true. No facts have been determined at this point, but even if you assume it's true, they have failed to state a claim on which relief can be granted. That's a motion to dismiss. So the standard is pretty high, right? Because again, we're not talking about facts. We're just talking about, we don't have anything, we haven't done any fact checking at this point. NAR argued in its motion that the lawsuit misportrayed the rules for multiple listing services, and the plaintiffs failed to show they suffered any antitrust injury, according to an article from Inman. And NAR says the same thing. The judge dismissed the motion that NAR had filed, and specifically stated that but for defendants' conspiracy, each plaintiff would have paid substantially lower commissions. So it's this idea that there has to be an offer of compensation. And you do recall, everybody, that you don't have to offer any particular compensation in MLS. It can be, it can be nothing. It can be $1. It can be a penny. NAR and the MLS does not dictate the amount of compensation that's being offered. But that's, the argument is that because this offer of compensation is required through the MLS listing, that disadvantages the buyers and creates a situation where people pay more for properties and seller get less in their pocket. Anyway, this is what the judge said in response to the motion to dismiss. It's not obviously definitive of the case. I'm sure Katie will tell you when she talks to you at the board meeting that NAR feels optimistic that they will prevail in this case. It's just, the first hurdle, and unfortunately they weren't able to make it. So it will continue, and now it will go into discovery, and there will be lots of depositions and lots of requests for production of documents and various things during this discovery process. And then when you get all through this discovery process, I'm sure there'll be a lot more motions filed during that process. Then you may at some point get to a settlement or to a jury on this, but we're still a long way away from any of that happening. So just have to hang tight on that. Also, NAR was hit with a lawsuit from the Department of Justice. And the allegations that the department made was that again, it had to do with these MLS rules, that they resulted in a decreased competition among real estate brokers by prohibiting the MLSs that are affiliated with NAR from disclosing to prospective buyers the commission that the buyer broker will earn, by allowing buyer brokers to misrepresent to buyers that the buyer broker services are free, by enabling the buyer broker to filter MLS listing based on the level of broker compensations being offered, and by limiting access to lockboxes that provide licensed brokers with access to homes for sale to brokers who work for a NAR affiliated MLS. So they alleged that there was a conspiracy basically between NAR and all of these. That's how, conspiracies work, right? There's more than one player involved. NAR and all of these independently owned MLSs, that the rules created this conspiracy by doing these things right here that were antitrust or anti-competitive in nature. But in November, NAR and the DOJ reached a settlement, so that's not going to proceed through the courts. They have agreed. The DOJ will dismiss the lawsuit, and NAR has agreed to modify its MLS policies to provide greater transparency to home buyers about the commissions of brokers representing home buyers, buyer brokers, to cease misrepresenting that buyer broker services are free, to eliminate rules that prohibit filtering MLS listings based on the level of buyer broker commissions, and to change its rules and policies which limit access to lockboxes to only NAR affiliated real estate brokers. So do you hear that, guys? You can no longer limit access to lockboxes to only NAR affiliated real estate brokers. That came out of this as well. So greater transparency to the buyer about how that commission is getting paid. And as you recall, we made some changes to our buyer broker agreement last year, and we explained that whole process in there, which we'd never done before, but we were moving in this direction even before the DOJ stuff, that explains normally this is how a buyer broker gets paid. And so we are making an effort to try to explain that. You will see rules that are coming out of NAR that are going to do things to provide greater transparency in regards to how buyer brokers are getting paid to buyers, of course, because that's who doesn't know about this stuff. But I think one of the big things that you guys are going to see here is this change to policy that disallows lockboxes, disallows limiting access to lockboxes to only NAR affiliated real estate brokers. So we have not seen these rules yet, but they should be out any day now. I mean, I think that they had from the date of settlement, I think they had now I'm thinking 90 or 120 days to get these things done. So we're right at that point now, coming up on that point in the next month or so. And so we need to be watching for those, and the MLSs, I'm sure, will be on top of it, and I'll be publishing, and NMAR will be publishing information as it becomes available. But you are going to see some changes to those rules in the next month or so, and they're working on those right now. The DOJ said in their lawsuit that home buyers and sellers should be aware of all broker fees they're paying. The settlement prevents traditional brokers from impeding competition, including by internet-based methods of home buying and selling, and providing greater transparency. And this will increase, in the DOJ's opinion, price competition among brokers and lead to better quality of services for home buyers and sellers. Again, this is what DOJ says about this whole thing. 45 days. There we go, guys. Sorry about that. 190, 145 days. That's why I knew it was coming up, because this was done in November and we're already into January. So the NAR board of directors will have to approve the new rules once they are adopted by the committee. The court overseeing the settlement must formally approve the agreement. So once, I guess, the rules get in place and the agreement is approved by the court, and the new rules will take effect. And there you have it. So yes, we will be watching for those in the very, very near future. The rules, we have an idea of what the rules are going to say, but we don't have the exact rules, as I said. But the rule that amount of compensation offered brokers for each MLS listing will be made available. So, for example, when these things, especially when they're sent out on the public-facing websites, it's going to include what the buyer broker is going to be making from it, what the compensation of offer is to that buyer broker. That's going to be a public field that's available for everybody to see. They're also going to be passing a rule that affirms that MLSs and brokerages must provide consumers all properties that fit their criteria, regardless of the compensation offered or the name of the listing brokerage. And we may have to revisit our buyer broker agreement on that. We'll have to see how this rule what this actually says, and whether or not that can be actually kind of, if the parties, the buyer's broker and the buyer, can actually agree to something different. Because one of the provisions of our buyer broker agreement is in the event that a certain amount of compensation isn't being offered, that either the buyer doesn't need to see those properties, or the buyer will make up the difference of that compensation. So how that's going to fit into our buyer broker agreement, and whether or not we're going to have to make some modifications to that, is yet to be seen. But the rule will affirm that MLSs and brokerages must provide consumers all properties that fit their criteria, regardless of compensation offered. Again, not sure if there's going to be any wiggle room in there for the parties to agree otherwise. We'll see how that plays out. A rule that states that the buyer's agent cannot represent that their services are free to clients. I don't know if anybody's doing that, but in the event that it's happening, we have to make it clear that they're not free. Somebody is paying. It's the seller who's paying the listing broker, who's paying the buyer's broker. And so at the end of the day, they're not exactly free. But nonetheless, that's going to have to be made clearer to buyers. And a rule required that with the seller's approval, a licensed real estate agent will have access to the lockboxes of properties listed on an MLS, even if the agent does not subscribe to the MLS. So these are licensees who are not NMAR members or not GAR members, not LCAR members, not local board members. They're not realtor members, guys. They still have to have access to the lockboxes. So this is what we anticipate. The exact verbiage, again, we don't know what it's going to say, but we will be watching for it. I have a few kind of questions that came as a result of this that I want to answer, and then we'll take our break. There's a home in the MLS that I think my buyer client would love, but the commission being offered by the listing broker is lower than what I want to be paid. It's so low that it won't even cover the time or effort I put into representing the buyer throughout the transaction. I want to do the right thing, but what can I do? Right? So that's going to be the question. Since you believe your buyer would love the house, you have a duty to show that house to your client, right? You have a duty under your local duties. You also have, or your state duties. You also have a code of ethics duty. But you do also have a right to address the fact that the compensation being offered is lower than what you would like to work for. Buyers and sellers can negotiate the commission paid to their brokers and agents at any time, okay? And consider using a buyer broker agreement. We've talked about the buyer broker agreement. We revamped it. It's a really great form now, guys. I know that in a lot of cases, brokers don't use buyer broker agreements, but I really encourage you to do so because, as I said a moment ago, it does say in there, if there's a listing and you want, that I want to show you, but the offer of compensation is inadequate to cover me for my time, and we talk about this in the agreement, then the buyer is agreeing to pay you a difference up to a certain percentage. So if the listing broker is offering 1%, and as a buyer broker, you want to work for 3%, then you can get a buyer broker agreement in place that talks about the buyer compensating you for that additional 2%. So those buyer broker agreements, I think, are going to become more and more important, guys, because you can't, if there's no way you can filter out any, what you're going to be paid on this. There is an exception. You could ask the listing broker to negotiate the offer of commission or renegotiate the offer of commission. But there's one exception to that, right? We know what the Code of Ethics says in that regard. You may not submit an offer to purchase that is contingent upon an increase in the commission paid to you by the listing broker. An offer of that nature is thought to be inconsistent with your duty to the client. And this request can be made at any time during the transaction, even after showing the property. So what this is saying, guys, is that, we always think, oh, we can't renegotiate the offer of compensation that's been offered by the listing broker in the MLS. That's not true, okay? What the Code of Ethics says is that you cannot make an offer contingent on them changing that offer of compensation. So you can't say to your buyer, let's put on an addendum that you'll only buy this property or you'll only pay this much for this property in the event that the listing broker agrees to pay me, your buyer's broker, more money than they've offered in the MLS. That's what's not permitted, okay? It doesn't mean that you can't renegotiate offers of compensation through the MLS. So you could have a conversation with the listing broker about the commission being too low to cover your time and the cost that you're going to incur in connection with representing the client. And if your client so wishes, he or she could make the decision to condition the offer to purchase the property on an agreement by the seller to pay the additional specific amount. The buyer and the seller are parties to the contract to purchase the listed property. They can negotiate the terms of the contract as they see fit. Just make sure that your client completely understands the pros and cons of submitting an offer with that type of contingency, and make sure not to pressure your client in any manner that is inconsistent with your fiduciary duties, which we don't work as agents here in our state. We work as transaction brokers. So you can sub that out for broker duties. Don't do it in a manner that's inconsistent with your broker duties to your client. Okay. So you can renegotiate with the listing broker. You can go to them at any point in the transaction, and say, are you willing to pay me more? Because I don't think this is enough, right? I don't think this is fair. And see if they'll renegotiate. If they don't, you can have a conversation with your buyer that says, buyer, I'm only going to make this much off of this. Our buyer broker agreement, for example, says you're going to pay me the difference of 2%. But you could ask the seller to pay for that. And that could be part of the purchase agreement, is you have to agree, seller, to pay my broker that 2% that I'm obligated to pay, or maybe even even if there's no buyer broker agreement in place that my buyer's broker feel they're entitled to. You can negotiate that in the actual offer. So be clear about what's prohibited by the Code of Ethics and what's allowed by the Code of Ethics, because there is a way to deal with this. And this is, this has really come to light and is really at the forefront given this DOJ settlement. And so going back to what I said before, doesn't the standard of practice 16-16 prohibit me from negotiating my compensation or commission after showing, during the purchase of the offer phase, or after we've accepted the offer? The answer to that is no, absolutely not. You cannot, again, condition an offer to purchase on the listing broker changing that compensation. So that can't be included in your purchase offer. But it never prohibits negotiations between the listing broker and the cooperating broker at any time during the transaction. In fact, Standard of Practice 3-3 expressly authorizes the listing broker and cooperating broker to come to an agreement to change cooperative compensation that can happen before the property is shown, after showing, or even after the offer is accepted. Let's move on to changes to the Code of Ethics. The NMAR Code of Ethics. So there's a new standard of practice under Article 10 that prohibits discriminatory speech and conduct. And there has been revisions to the definition of public trust in the code. So changes to the Code of Ethics. The big deal here, guys, is it expands beyond your realtor activities. The Code of Ethics, of course, you guys are all governed by the Code of Ethics because you're realtor members. And the policy statement says that members cannot engage in conduct and speech that is discriminatory and important, unless it can be tied to a real estate related activity or transaction. The code, specifically Article 10, does not apply. So in the past, it has been any kind of activity or conduct in this regard had to be tied to your real estate world, your real estate activity. But the revision to the rule now expands that applicability to all realtor activities. So not all of the code has been expanded, but this particular provision of the code has been expanded. Realtors may not harass or use hate speech, epithets, slurs, any kind of discriminatory slurs regarding color, religion, sex, handicap, any of the protected categories. And the proposed standard of practice directly flows from the requirement, and now it's actually adopted, it's not proposed. It directly flows from the requirement to not deny equal professional services to any parties in the transaction or to parties that you plan to do business with. Specifically, bias against protected classes revealed through the public posting of hate speech could result in realtors not taking clients from certain protected classes or not treating them equally, which would lead to, of course, fair housing violations. So at present, the definition of harassment, some of the terminology that they're using is just our general terminology. Again, it expands the definition to include all discrimination against protected classes under Article 10 and all fraud. As a result, associations are now required to share with real estate licensing authorities, the Real Estate Commission, final ethics decisions holding realtors in violation of the Code of Ethics in instances involving real estate related activities and transactions where there is a reason to believe the public trust as expanded may have been violated. These new ethical obligations would not apply to behavior that occurred before they became effective. So any complaints must be filed within 180 days from after the date of occurrence, but not for things that happened before this rule was adopted. The comments that I've gotten about this is, this prohibition that any kind of discriminatory comment or conducts can lead to a Code of Ethics violation, even if you're doing it on your own private Facebook, if you're doing it, in a context that is completely unrelated to real estate. One of the things that people have said is that it seems to limit my free speech, that I can't say what I want to say when I want to say it. How can NAR do this? Well, and I've actually had some comments on the hotline to that effect, and I've had to explain that the First Amendment doesn't protect you against private groups regulating your speech, or it just doesn't apply. The First Amendment applies to the government coming in and trying to do something like that. That's where your First Amendment rights come in. But it does not prohibit a private organization from restricting the speech of its members, employees, or users. And NAR, of course, is a private association. It's supported by member dues, but it's not exercising any governmental functions. It has no subpoena power, doesn't have any other powers generally available to state agencies. It's a private organization. So therefore, the First Amendment does not apply. And the thought process behind that is kind of like, if you don't like the way an organization is run, then you have, you can try to change it, through that process that you change rules within the association. And then if you still don't like the outcome, then of course you don't have to join. And that's the whole thought process. So again, First Amendment doesn't apply to what NAR is doing. The thought process on this is that realtor speech and conduct affects the whole realtor organization, and it reflects on all realtors in general. The preamble for the Code of Ethics should be guided by the spirit of the golden rule of treating others as one would like to be treated. And when you become a realtor and you pledge to abide by the code, the highest principles and ethics of realtors must be followed in all of their activities, not just their real estate activities, and cannot be abandoned in a profession dedicated to protecting the best interests of consumers. So when one realtor engages in discriminatory speech and conduct, those actions demonstrate to consumers that they represent the actions of all realtors. That's the position of NAR. And discriminatory speech and conduct depletes the strength of the brand. And this change does not mean that, again, that all aspects of the Code of Ethics applies to your personal life, but Article 10 does apply to your personal life. So again, while the focus of 10.5 is to eliminate loosely termed offensive or discriminatory speech, hearing panels should be clear that the standard of practice is narrowly limited to conduct related to the requirements of equal professional services under Article 10. The focus on types of speech that might be subjectively deemed offensive or discriminatory by one person and not another, that's not what we're dealing with in 10.5, okay? It's not a subjective kind of a view. I mean, some people may be more sensitive than others to these type of things, but we're not talking about a subjective of being offensive subjectively or discriminatory subjectively. It's an objective. I mean, the reasonable person standard, right? The standard of practice is based on very particular types of speech that are directly connected to protected classes, race, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Those are the protected classes under Article 10. NAR's Code of Ethic and Anti-Harassment Policy clearly defines harassment and includes inappropriate conduct, comment, display, action, or gesture based on another person's sex, color, race, religion, national origin, age. Again, all these protected classes. Examples of harassment include, but are not limited to, epithet, slurs, negative stereotyping, threatening, intimidating, or hostile acts, certain types of jokes, display of certain type of written or graphic material. These are the kind of things that fall under this definition of harassment. As sexual harassment includes verbal and nonverbal, physical, non-physical, sexual innuendos, jokes, comments, nonverbal, sexually suggestive objects or pictures, graphics, commentaries. Hearing panels should look to the existing information on harassment to determine whether harassing speech has occurred, and look to determine whether the harassing speech was based on one of the protected classes. They use the general definitions of hate speech and epithet and slur that you find in Webster's dictionaries. So hate speech is defined as speech that's intended to insult, offend, or intimidate a person because of some trait, characterizing word or phrase, an epithet accompanying or occurring in a place of the name of a person or thing, a disparaging or abusive word or phrase, and slur, an insulting or disparaging remark or innuendo. So these are just general definitions that they use for these particular, hate speech, these words that you can find in the dictionary. Hearing panels need to look at, this slur or this speech or this discrimination, and determine whether or not they fall in, it falls into this category. And under the Statement of Professional Standards, Policy 29, realtors are subject to the Code of Ethics standards in all of their activities. So that's a violation of Article 10 is supported by the Standard of Practice 10.5 can occur when a realtor uses harassing speech, hate speech, epithet, slurs based on the protected class in any media or context, regardless of whether related to their activities in the real estate business or their identification as a realtor. Okay, that's the big deal here. And I don't know how many of you guys participated in that board meeting or have been reading much about this online, but it got a lot of attention. There was a lot of concern about kind of this overreaching on NAR's behalf, but at the end of the day, guys, it passed. This is what the board has decided. So this is what's in place right now. So you need to be very careful that you're not violating this in other contexts, because it can result in a code of ethics complaint against you. And it can also can be reported to the real estate commission. They'll take their own action against you as a result of this, the discrimination or the speech. So, doesn't this mean that if I post my opinion online and someone doesn't agree with it, I can lose my membership and be forced out of business? Well, as with any alleged code of violation complaints, there is a process, right? And there is a code of ethics process. You have to go through a hearing. You get to present your case. The process affords all parties a full and fair opportunity to present their case, defend themselves, provide evidence and witnesses, and also be represented by legal counsel. Broker counsel, if you want to, a broker can represent you in that capacity, or legal counsel. Additionally, membership as an association is voluntary, and any discipline imposed does not automatically impact your ability with your license. Now, as we said, it can be reported. The public trust issue can be reported will be reported to the, if they find that it's a violation of public trust, it will be reported to the real estate commission. Of course, the real estate commission does have that ability to impact your license. If you find yourself in a similar situation where a client violates the fair housing law, be sure to follow the best practice. So if you end up working with somebody who you feel, whether it be buyer or seller or landlord or tenant, who's in violation of the law, remind your client of their obligations under federal fair housing laws, discontinue representation of that person, report the situation to your broker if you're an associate broker, document the situation in writing, including what actions you took in response to your client's violations. If you're unsure whether a client's actions violate housing laws, consult with an attorney and include a clear statement of your commitment to upholding fair housing laws in your listing agreements and other communications with your clients. For more information on this, you can visit the NAR webpage here that you have on the screen. And when you download this is a link, so it'll take you directly there. You don't have to type it all in. But they have a bunch of frequently asked questions on this topic, additional explanation on why it was passed, these kind of things. So if you're interested, please look at that and so that you're very familiar with how these things can impact you, because it really is kind of a deviation, a difference from the way that we've been doing things, right? Everything's always been tied to you as a realtor as far as the code of ethics is concerned. And now it's kind of expanded to something beyond that. So just be careful and be aware and be cognizant. Not that I think any of you guys are doing anything that I'd be concerned about, but in the event you have concerns, please take a look at this page. Okay, let's talk about some forms, shall we? We only really have two, and one really small form to talk about today, guys. So that's not bad at all. I will remind everybody that we did release some forms in August. I covered these at my last update a little bit: a bill of sale, a seller's bonus, buyer's bonus. So this is in the event that the seller has offered to pay a buyer's broker a bonus. And you see this in the MLS perhaps, but the listing broker isn't making that promise. It's the seller who's making that promise. And the buyer's broker really needs to get something in place with the seller that requires the seller to pay that bonus to the buyer's broker. So make sure you guys are using that. Obviously, the bill of sale is for personal property that's sold outside of the contract. And that's between the parties. It's just available for use between the buyers and sellers if they're selling property outside of the purchase of the property. The inspector copyright release. We've talked about inspector copyrights kind of ad nauseum, haven't we, guys? We've just talked about that to death. We have an inspector release. So in the event that you have an inspector's report, it has copyright language on it, you want to share it with another buyer. The first deal fell apart. Now you've got it. Seller wants to share it with another buyer, that you can ask the inspector to release their copyright to allow for that sharing. And in a perfect world, you could get the inspector to sign off on this copyright release. If you can't, if they won't sign it, or if they, you don't want to go to the trouble of doing that, at least get something in writing from the inspector saying it's okay for you to provide that information. Don't just take the word over the telephone. Make sure you get something in writing, an email or something. We have a radon information sheet that's new and out there. We have an escalation clause addendum that is out there. You guys, I'm not going to go over the escalation clause again, but I want to reiterate how that form works very quickly. And when you get an offer that has an escalation clause addendum in it, and your seller makes the determination that they want to accept that offer, then there is a counter offer form that has to be created by the seller and sent back to the buyer. And that counter offer form has to incorporate the new dollar amount that the parties have agreed to as far as the purchase price is concerned. And that purchase price, of course, was arrived at through that escalation clause. But that number, whatever that number is the purchase price, needs to be incorporated into that new counter offer. The other thing I want to remind you guys about on the escalation clause is there is a provision in there for the waiver of an appraisal. So the appraisal might, come in low, but the seller the buyer in this kind of bidding war they were in said, hey, we'll waive the appraisal. I don't care where the appraisal comes in. I still want to buy this house for the dollar amount that we agreed to. Well, that's all fine and good as long as the buyer isn't getting a particular type of loan, because FHA loan, for example, VA loans, for example, they will not allow a waiver of the appraisal. And when the buyer goes to get that loan, they're actually going to require the seller to sign something as well that says, in the event that this appraisal comes in low, this buyer can walk with getting all their money back and no penalties whatsoever. So if you get an escalation clause in and you see it's a VA loan, an FHA loan, then you're immediately going to be, and they want to they want to waive the appraisal contingency. You immediately know that can't happen, right? I mean, it doesn't matter. It just can't happen. And we have language in there that says, hey, if a loan program won't allow it, I don't care what the buyer says, there's no waiver of the appraisal. So just be aware of that as a listing broker, buyers brokers as well, but we've kind of built in some language to protect the buyer side of it. Sellers need to be aware that language is in there. So the appraisal can't be waived in certain circumstances. There is a section in the escalation clause dealing with a section in there that talks about how the parties are going to be where the money's going to come from. For example, the difference in, the additional amount that the escalation clause has increased the purchase price. We're probably going to be discussing taking that section out. I realize at the time that those offers are being made, perhaps that information is unknown. We're not really sure how the money's going to come, whether it be built into the loan or whether cash be coming to the table or how it's going to be handled. So we're going to revisit that particular section of the escalation clause, maybe at our next Forms Committee meeting. And as far as acknowledgement of transfer is concerned, I'll talk about this a little bit in one of my other topics from the hotline, but that's a form that is available in the event that you have a broker in an office who's representing a buyer. There's no buyer-broker agreement in place with that buyer, and that broker who's working with that buyer is going to move to another brokerage right in the middle of a transaction. Right. So there's a pending purchase agreement going on, and this broker wants to move to another brokerage, and there's a pending purchase agreement. That acknowledgement of transfer, which I'll talk again about in a minute, is to help facilitate that move for all parties. So we'll talk about that in a minute. Let's move on to the forms that are being released probably at the end of this month or the beginning of next. Some revisions to the residential purchase agreement, which is our Form 2104, and some revisions to 2301, which is our seller's property disclosure statement. That's been revised. So first things first, our 2104, we have an index, guys. This is cool, isn't it? Look at that. So it's all alphabetized. In the event that you need to know where the inspection paragraph is, you can go to I for inspections. You can see the paragraph number. You can see the page number. This will not say X is all down on the right-hand side. We are still finalizing this. So this is the very first page of the purchase agreement, so it can easily access the information that you need or your client. I mean, really, you guys are probably familiar with all these paragraphs and where they're located within the form, but I can assure you your client is not. So if they want to know, okay, what does it say about, anything, whether it be the home warranty contract or whether it be, the opportunity to cure, which we'll talk about in a minute, or prorations, now it can be easily accessed by this index. That is the very first page of the form. On broker duties, we talked about this, the new commission rules. And so we have eliminated this section that says any other written agreements. That's been taken out. That's no longer on broker duties. And then we added the section that requires, if you're not going to be providing the full gamut of services that you as a listing broker, those limited service brokers have to disclose that to the other brokers in the transaction. They have to be aware of the fact that you're not functioning, you're only functioning in a limited capacity. So that's been changed. I didn't talk about this during the section on changes, but I'll mention it now because it is of relevance. The transaction coordinator language in the broker regulations has changed a little bit. It used to say that a transaction coordinator could be a licensed or an unlicensed person, and then whether or not they had to have a license really just was dependent on what they were doing, right? If they were doing things that required you to have a license, you had to have a license. Of course, that begs the question, what are the things you have to have a license for? And we had some guidance because we have a list of things that assistants can do, like unlicensed assistants can do, and a list that they can't, of things that they can't do. So we had that guidance. And then of course we had the general definition of what is a real estate broker. So that of course gave us guidance as to what a license, you need a license to do. But the reason for that is because that term, transaction coordinator, has been around for a long time. I mean, that terminology has been used to reflect things that unlicensed people have been doing for a very long time, whether it be making some phone calls, setting appointments, pushing paper around the desk, whatever it is they're doing, that term has been around. So I know that when they originally proposed saying that transaction coordinators had to have licenses, all of a sudden, there was a lot of pushback on that because brokers said, well, no, I use transaction coordinators, some of them not even in the state, some of them not even in the country. And they don't have New Mexico licenses, but they're not doing things that require you to have a New Mexico license. But they called them transaction coordinators. So originally when the definition was created, it wasn't tied to the name. Whether you needed a license or not wasn't tied to the fact you were a transaction coordinator. It was tied to what you were doing and whether or not you were doing something that required you to have a license. That's kind of changed now. What they say now is that if you call yourself a transaction coordinator, you have to have a real estate license. That's what it says. It actually says you may have to be licensed. And in talking with Wayne about, well, what do you mean may? Well, like, what are the circumstances under which, if you don't have to have a license? And he said that it was kind of an oversight that they use that term may instead of requirement that you had to have a license. Because we were, he really wasn't coming up with any circumstances under which you could call yourself a transaction coordinator and not have a license. So just by the nature of using that terminology, like using real estate broker, right? You can't call yourself a real estate broker and not have a license. You have to have a license if you're going to call yourself a real estate broker. Now that's true of transaction coordinators as well. If you're calling yourself a transaction coordinator, you need to have a license. If you are doing things, might even be similar things to what transaction coordinators do in some respects, and you don't have a license and you don't need to have a license, then you are an unlicensed assistant. That's what you are. You're not a transaction coordinator. You were an unlicensed assistant. So anyway, with that said, we modified second page here just a little bit, taking out all of these provisions regarding the types of duties that are owed by licensed TCs because that's now been eliminated. Now if you're licensed, you're a transaction coordinator, you're licensed. If you're licensed, then you owe the broker duties as set forth on paragraph 1, right? I mean, on page 1. There are certain broker duties you owe to everybody in the transaction and certain things you owe to the party who you are directly providing services for. And that's the same now with your licensed transaction coordinators. So all of this section here, breaking those duties out, has been eliminated. And we now just have a section at the bottom as far as TCs are concerned that explain that, they're licensed. We explain what they are, of course. These are the kind of things that they may be doing. And the broker duties owed by transaction coordinators. And we reference it back to page 1. So broker duty page 2, cover page 2 has been changed a little bit to reflect this change in transaction coordinators. Page 1 of the actual purchase agreement, it looks a little bit different, but it doesn't really, it's not substantively, it's not tremendously different. Paragraph 1 looks a little different. Paragraph 2, we said the sum of A and B, and we say under A, cash due at closing. Off market section has been changed a little bit because it's no longer directly tied to what we used to call the TOM inspections. We called them the TOM inspections. So the time off market inspections, which would allow, those initial inspections to take place and review of the seller disclosure statement. We now just have a time off market section, which says that in the event that there is going to be compensation for the seller to take the property off the market, then, that's where you would mark paragraph 3. And it doesn't mean it's to the exclusion of earnest money. You could have both of those things, but we no longer use the term, the TOM inspections. The rest of the paragraph looks the rest of the page looks very similar. We've added a couple of things on page 2 under the personal property. We broke out audio and video components into 2 sections. We have freestanding ranges opposed to ranges, obviously, that are not freestanding, that are built-in ranges. We added some S's to the end of some of these things. And we also provided for garage door remotes to have a certain number of garage door remotes. Of course, buyers are going to always ask for, I don't know, all, or they're going to ask for 3, or they're going to ask for 10, or how many they ask for. And unless you listing brokers don't want to be buying garage door remotes, you might want to check that number. If the number of the garage door opener is left blank, then seller's obligation shall be no more than 1 working remote. So if you as a buyer's broker don't put anything in there for your buyer, then what you're going to get is 1 remote. That's all that's going to be required. You might get more than 1, but as far as being required, you're only going to be, the seller's only going to be required to provide 1. This looks different. This cash loan or seller financing section is different because we're asking for how these cash funds are going to be coming, right? So we want to know, are they readily available funds? Is this money you just have sitting over in your checking account that you're going to release? Are they contingent on the closing or cash refinance of a property? That might be something that might be relevant to the seller, that they're waiting on this refinance of their property. Until that occurs, they're not going to have the cash. Is there something else that's going on? And then we create another deadline, guys. No later than so many days after the date of acceptance, the buyer shall provide seller with verification of funds and proof satisfactory to seller that the buyer has in buyer's possession or control the funds necessary to complete the transaction. And failure of the buyer to timely deliver those proof of funds shall be considered a default. And in the event of buyer's default, the earnest money, if delivered, shall or shall not be refunded to the buyer. So we have a deadline. If you're saying you're paying cash, we don't want just, we're going to want to see the verifications of those funds and proof satisfactory to seller that that cash is available by a certain date. And if it can't be provided, then that results in a default. In the appraisal section, we have added some language because unfortunately, this just keeps coming up. The appraisal is for the value of the property. And sometimes, obviously, you know, the value comes in, but the square footage is significantly less, some less, significantly less than what the buyer thought. And it may be just because, you know, I like to always tell the listing side of this that they need to be using something, not pacing it off themselves. I've had this conversation. Don't pace it off yourself. Rely on some other documents. I know most of the MLSs will say when you enter the square footage information, where you got that information. Was it from county records? Was it from a prior appraisal? Did you have the house measured? Where are you getting that information? But what's happening, obviously, is that the buyers are not doing any kind of square footage analysis until they get to the appraisal section. And then they're relying on the appraisal to do that for them. And they're thinking they have the right to terminate the contract, or that the appraisal contingency kicks in if the square footage is off. And they learn of that during the appraisal time, which is often way past when the inspection contingency deadline has occurred, right? So what we're telling them here in this section is square footage has to be done during the inspection phase, right? The appraisal contingency does not allow for termination based on a discrepancy because of representations or assumptions of square footage and appraisal square footage. And that got cut off because that's just the gist of it, guys. It's telling them right here that you cannot use this appraisal contingency to terminate the contract based on the fact the square footage is lower than what you thought. Okay, that's not what this is for. If the number comes in, if it doesn't come in, it's a non-issue because we know if it doesn't come in, you're going to be renegotiating. But if it comes in, then that's all the appraisal contingency deals with. So if square footage, and we say this elsewhere in the contract, is important, you should be looking at that during the inspection phase and objecting prior to the objection deadline. Okay. The assessments paragraph has been moved into the title paragraph. It made sense. I mean, that's when you're going to find out about these assessments. So it makes sense that those 2 deadlines for objecting would all come into play at the same time. And so we've moved that objection section for assessments into the title section on page 5. This is something we're actually talking about at our next meeting of the Forms Committee. And we hadn't initially incorporated this into the changes, but over the last month, I've been so inundated with this issue that I asked the Forms Committee chair and vice chair if we could incorporate it with these changes that we're getting ready to release next month. And this has to do with title commitments not getting done timely. The market's been incredible, guys, hasn't it? I mean, I'm just thrilled for you all. I mean, you guys have been working to death, and it's been a great market. But some of the third-party servicers that we rely upon, whether it be lenders or inspectors or things like that, title companies, are not able to really keep up with this demand. And as a result, they are getting so far behind. Also, we have really limited number of title companies in some of our areas. I know it's less of an area in Albuquerque and Las Cruces and Santa Fe, perhaps. When you get into some of the more rural areas, for example, Farmington still only has one title company up there. Taos, I think, has two, but boy, they're so booked and behind. Areas down in the southeastern part of the state are experiencing the same thing. So the question becomes, because I always say, there are only two parties to a contract, right? So when something doesn't happen the way it's supposed to happen, it's either the buyer's fault or it's the seller's fault, because we can't blame it on these third parties because they're not parties to the contract. So we look to whose responsibility it is to make this happen. If it's a loan, for example, the buyer's the one that needs the loan. So the buyer doesn't get their stuff together in time to get the loan. Even if it's not the buyer's fault, even if it's the lender who's backed up for whatever reason, that's going to fall on the buyer. But the title is a little bit different because we have the seller saying that they're going to convey the property and that it's free of all liens and all of these kind of things. And we kind of need the title information to confirm all of that. The buyer is wanting a title policy and the seller is willing to pay for that in most cases or in some areas of the state. Anyway, it's a little less clear about when that title company doesn't perform, who do we blame, the buyer or the seller? And really what we've decided is it's really hard to blame either one of them, but it's happening all the time where the commitment is not getting done in time to meet those closing deadlines. It's happening throughout the state. And I guess there are worse problems to have. But we have built in this auto extension, or I'm proposing this auto extension to deal with this situation. As far as the time frame, we have talked about the time frame. I don't know where we'll end up. I plugged in, I think, 14 days. As somebody said, who's in one of those areas where the title commitment is lagging behind 60 days, 30 days, long periods of time, they wanted that number increased a bit. So that number may be increased as the default number. But as you can see, it also allows the parties to put in another number that they may agree to for an automatic extension. So if you want to do something less than whatever that default number is, then you can say something less. If you want to do more, you can do something more. And it allows for that settlement signing date to be automatically extended until that title commitment comes in. But it also doesn't leave the parties just hanging out there indefinitely. In the event that if the title company is not able to issue a commitment at the expiration of the automatic extension, either party has the option to terminate the agreement by delivering written notice to the other party, and the earnest money delivered by the buyer shall be refunded. And then everybody's released from further obligations. The parties can always agree to further extend. Of course they can. There's no obligation that if they don't want it to just terminate, or for either party to be able to terminate it at the end, they want to keep going, they just enter into another extension, guys. They just keep going. But I had a situation with a broker representing a buyer. This buyer had gone on like 3 extensions with her lender, waiting for this title commitment. And she was paying for every extension to get every extension. And it just became cost prohibitive for her to continue. And it was still no end in sight to when they were going to get this commitment. So anyway, we're going to be talking about this with the committee. And in the event that they agree to adopt something along these lines, you will see this as a change in the purchase agreement that's coming out. In the cost to be paid grid, we've added elevation certificate, and we've added the home warranty plan in the grid. It was in another section. We still have a section, but as far as the cost to be paid, it's now moved into the grid. Under the surveys or improvement location report, we have added, I think, the floodplain designation, flag corners if located in floodplain designation. So this is a new section that's been added to this survey or improvement location paragraph. This is a provision, as you guys recall, that used to be in a separate paragraph, because we used to say that prior to the buyer entering into the contract, they were attesting, affirming warranting that they had investigated the area, that they had investigated, maybe registered sex offenders who had lived in the area, the presence of, any kind of structure or business or building or activity that was going on that they didn't like. Because these are things that they could ascertain prior to the time they entered into the thought process. Was they could ascertain this prior to going into the contract, right? They could drive around the neighborhood. They could, do their sex offender search before going into making the offer. But then the market became so hot, and the reality is that buyers weren't doing these things before they entered into contracts. And then because it was supposed to be done beforehand, obviously it didn't provide them with any kind of out if they learned about one of these things after they were already under contract. And so the committee decided that we might as well just move this under the inspection phase and make that part of their due diligence once they're under contract. And you guys, going back to page 1 of the contract, the time off market, I know that has met with a lot of resistance, but one thing that sellers need to understand is that in the event that a buyer gives earnest money, and this is so important, and I've said this 100 times, guys, the reason buyers and sellers get upset in contracts, the reason you find them at odds about earnest money, most of the time, not all the time, but most of the time at odds about earnest money or angry with you, is because they didn't understand the terms of the contract going in. And they click through the entire, form that you sent them electronically. They initial the way they have to, they sign the way they have to, and they read very little. They just don't. And so they don't know it's coming when it comes. And one of the things they don't know is coming when it comes is the fact that earnest money has been deposited and the buyer has this due diligence period where they can walk away for pretty much any reason, guys, any reason, right? And now we moved another reason in there, right? So now they're not even testing that they've walked around the neighborhood first or done a sex registry, a search before they went under contract. So they can walk away for any reason and they're going to get their earnest money back, right? And that's the way the contract works. And we'll talk about that in a minute as well. But they need to understand that so that when it happens, they're not taken aback and they're not angry and they're not, wait a second, I had my property off the market for 3 weeks. What do you mean they can just walk away because of this, or 2 weeks, or whatever it was? The conversations about the time off market need to be happening when you enter into that contract. That's what the time off market fee is all about, guys. It's about compensating the seller for taking the property off the market for some period of time. And I've said this 100 times too. It's not just for the benefit of the seller. Yes, the seller gets some money in their pocket, right? They get to keep some money and they don't have to refund that. That's all going to be, they get to keep that. But it's also beneficial to the buyer, because what happens when a buyer finds something out during this due diligence period and they terminate the deal and the sellers didn't realize that's how the contract worked and they get angry and won't sign off on the release of the earnest money. Even though the contract says what it says, they just won't release the earnest money. And the title company, as we all know, they're not going to release the earnest money until such time as you have a written agreement or they get a judgment from a court saying who to give it to, right? And most of the time. So the buyer is held hostage, their earnest money is held hostage because you have a seller who didn't understand how this worked. And now they're irritated that they're not getting anything for having their property off the market. If the buyer could have paid a little something to that seller, so they didn't have to fight about earnest money and they could walk away for any reason, guys, that's completely reasonable, right? And many buyers would say, sign me up for that all day long, sign me up for that. So I really hope you guys are having conversations with your buyers and sellers about this time off market fee. Because again, that's most of the time that the parties are angry about the situation or angry at you, it's because they just don't understand and didn't understand. And it's only partially, your fault. Maybe it's, for not explaining it. They should have read the contract, but they didn't. And we know they didn't. So we need to point these things out to them, guys. Absolutely. Objections and resolutions. Okay. So, what happens when a buyer doesn't make their objections by the objection deadline? It's not a default of the contract, guys. It's simply a waiver of those objections, those inspections. They can't make objections. If they don't make them timely, they can't make them. It's as if they waive the whole inspection contingency. So it's not a default. It's just simply a waiver of the inspection contingency. So I think most everybody knows that, but we want to make it clear that is a deadline. And if it's missed, unlike other missed deadlines, it's not a default. Expiration date, we just have a definition of what that date means. It means the date the party is revoking his or her account offer or counter offer. And if it expires and the party intends to accept an offer, counter offer, the revocation, the expiration date is the date essentially the party reaches back over and grabs that offer or counter offer and pulls it off the table, right? So it's a revocation. It's the revocation date. It's the date at which it cannot be accepted after that date. But this expiration date definition or explanation also says if the party intends to make a counteroffer, it does not need to be made by the expiration date. I get this all the time. Oh, we can do, I don't know if we're going to counter this, but oh my gosh, the expiration date is coming off. We're going to need to extend the expiration date so that we can counter it. You guys, a counteroffer is a brand new offer, right? You're starting all over from scratch if you're making a counteroffer. So it doesn't matter what that expiration date is. It doesn't matter if you make it within that time frame. I mean, if you intend to make a counteroffer, you might want to let the other side know so the buyer doesn't go, look for another house and make another offer somewhere else. But as far as like, I got to beat that deadline, that expiration date, if you're making a counteroffer, it doesn't matter. Okay. This is a whole new way of doing things, you guys. So this is probably the biggest change in this form. So I hope everybody's paying attention. I know we're pretty well far into this and this is really riveting stuff, but I hope you guys are paying attention right now because we have a new provision in the purchase agreement that provides an opportunity to cure a default. And when we talk about a default, we're talking about deadline defaults. And that's why it's so important to understand that the failure to make your objections timely by the objection deadline is not a default, right? You waive your objections. We say that in that section. We make it clear it's not a default. We make it clear you waive your objections. Other deadlines in the contract, however, that have deadlines for performance, and you miss that deadline for performance, there is now a provision in the contract that says the defaulting party will have 2 days from from receipt of a written notice to cure the default. We call this an opportunity to cure period, right? And after the notice and opportunity to cure, the defaulting party fails to cure the default, then the non-defaulting party may elect to cease further performance. And then the whole default part, the paragraph that we have been in there and we understand is in full force and effect, right? That it's the same thing as it was. Nothing has changed. But now if there is a deadline default, the non-defaulting party has to notify the defaulting party and give them 2 days to cure the default. And the question came up, what does that mean for settlement signing? Well, that applies. What does it mean for, fixing, going in at the last minute even to make sure that during the walkthrough that repairs have been made and things like that. Any default of a deadline, guys. So we have to tie it to a deadline. If there is a deadline for performance, it doesn't occur. So that would apply to a settlement signing date, right? Because that's a deadline. It would apply to the production of the earnest money or the time off market fee or the production of the pre-qual letter or proof of funds. Or the delivery of a document of any sort. That's our grid that has all those delivery deadlines. Any of those deadlines that have to occur is when this is going to come into play. We have created a notice of default and opportunity to cure. So this is what it looks like. Seller buyer property, purchase agreement dated. And we put here date of full execution, guys. We have a tendency, and I kind of need to look at all of the forms in this regard to use the offer date on everything. And really the purchase agreement date is the date you have full execution of the document, or even better, as we define date of acceptance, the date that it's actually fully executed and delivered. But at least for purposes of identifying the purchase agreement, we should be using the date of full execution. Anyway, buyers, sellers hereby notify that they've defaulted under their obligations. This is the paragraph that you've defaulted. You can explain the default. It's optional. You don't have to explain the default. The paragraph might just speak for itself. You have an earnest money paragraph that says earnest money has to be delivered. It wasn't delivered. That kind of speaks for itself, right? You can add additional pages. If you want to explain further about the default, you can do so in additional pages. Again, not necessarily necessary, but nonetheless, it's an option. And it tells the party that they have 2 days from delivery to do whatever it is they were supposed to do 2 days ago, right? And it also reminds them about the definition of days. This is not a new definition of days. This is an existing definition of days that we've had in our contract for, I don't know how long, I mean, almost as long as I've been here. So it defines days as calendar days, but if the final day for performance falls on a weekend or legal holiday, then it rolls over to the next business day. And we have defined what the holidays, legal holidays are for purposes of calculating days. So this is the form that you would generate as a buyer or seller, whoever did not default. And you will send it to the defaulting party and tell them you've got 2 days to cure this. You've got 2 days to fix this, right? And if you don't fix it within 2 days, then you're in default and we can move forward with the default provisions of the contract. This is really new, guys. We've never had a notice to cure. It's very, very common in contracts. I mean, it's kind of odd that we've never had it, but it's very common in contracts to have some period of time to cure a default. So we have one now, and that's probably the biggest change we'll see. And this new Form 2350, that'll be released with the change to the purchase agreement providing for the notice to cure. Force majeure paragraph has been beefed up a little bit, guys. We kind of incorporated provisions of our, for example, our COVID addendum to the purchase agreement into this. It's not specific to COVID, but it does reference pandemics now. As I talked about before about force majeure is not a statute. And there's no case law that says these are exactly the things that fall into that category or what happens in that situation. It's completely dictated by the agreement between the parties. There are some contractual, there are some contract theories that may allow for, frustration of purpose or inability to perform that might come into play. But for the most part, force majeure is whatever it says in the contract. And when you have a really weak force majeure paragraph that doesn't really address a lot, the courts are not likely to expand it beyond what they see. That's just the nature of force majeure. So we kind of beefed this up to take into account some things. We did specifically call out pandemics or diseases or government authority, any action taken by a governmental authority taken in response to a pandemic. When we originally wrote our force majeure paragraph, I don't think we could have ever anticipated what was going to happen. And courts have not been enforcing force majeure paragraphs in regards to the pandemic or applying them to the pandemic when the language doesn't specifically call for it. So anyway, we've done that. We've also included some extensions for performance. So 10 days after the force majeure issue no longer is occurring, or no more than 30 days beyond the original settlement signing date. So something similar that we have in our addendum, but again, it's not limited just to COVID, it's to any of these force majeure events. Page 10, inspection reports. If buyer delivers an inspection report without seller requesting, I wanted to talk about this again, guys. And I know, I've been talking about it to death, but it's still happening. And I understand that we're trying to kind of erase and rethink years and years and years of these inspection reports when we just send them over to the other side willy-nilly and we don't even think much about it. And now the contract says something completely different. And, I talked about reasons why, sometimes it happens just inadvertently that those inspection reports are going from the buyer to the seller, even though the seller didn't request them. And sometimes it's happening deliberately. It's happening because the buyer's broker thinks that they have an obligation to make the seller aware of every possible thing wrong with the seller's property, even if it's just one inspector's opinion on one given day. Sometimes it's happening because they want their buyer to appear so reasonable. I mean, I'm only asking for 10 things for you to fix, and there's like 30 things I could ask for you to fix. Look at this inspection report. So very reasonable. Sometimes it's being sent kind of nefariously or for not necessarily a good intent, in the sense that they now say, oh, the seller's got this, I'm going to send it over. And then the seller's going to have this horrible report they have to disclose to the next buyer. And that way they'll negotiate with my buyer now because they don't want to have to disclose all those horrible things about their property. None of those are good reasons, guys. We have to be cognizant of the fact that this is how we set up the contract now. And as I've talked to you guys about it before, we've done it because the inspectors have copyright. They have a copyright on these reports, and they were getting very upset about how these things were being passed around left and right. Don't send them over unless they're requested. And in the event that they are requested by the seller, you have to send them over. So that's the other part of this, because sometimes buyers think I don't have to share the report with you, but that's what the contract says. If it's not changed, it says all the seller has to do is request it. So, again, in the event that there's a default of the contract, we talked about an opportunity to cure, but it's not a deadline default, right? It's not a cure. There's no way to cure that because it's not a deadline default, and the ability to cure applies to deadlines that have been missed. Obviously, once this horse is out of the barn, so to speak, there's no way to put it back in the barn. It's already been sent to the listing broker. It's already been sent to the seller. They now have the information. They're going to have to disclose it next time around. So this is not a cure period kind of situation. This is just a flow chart that I put together, and I'm thinking about making it available in the library because I think that it would be beneficial for consumers to understand how this whole inspection process works. So you're under contract and inspections begin, and then on or before the objection deadline, you have to do one of two things, right? You can terminate the contract. If you do, you don't send the inspection report unless the seller requests it. The earnest money is going back to the buyer. You're using Form 5105 and 5105B, the termination and the earnest money distribution form, and we're done. Or you go to the other direction. You object to an item in the inspection. You ask them to cure. You include the section, because that's what the contract provides for, the section of the report that supports the objection, and you send over an ORW form, a 5109, objecting to the particular issue, right? And then it tells you what your seller's options are. Your seller can either go over and cure everything. Oh, great. And then you follow that line around and the contract continues. Or the seller's other option is to cure some or none. And if they cure some or none, the buyer can then say, okay, I'm done, right? If you don't willing to give me everything I asked for, our contract is clear that if the seller comes back and doesn't give the buyer everything they've requested, that the buyer can then say, I terminate the contract. The ball's back in their court to say I'm done, right? Or the buyer can continue to negotiate until the resolution deadline comes, right? The other option, of course, is for the seller to offer a price reduction or a seller concession, right? And if that happens, they're going to complete the amendment form, right? And then either the buyer's going to agree to that or the buyer's not going to agree to that. Obviously, if we don't get any resolution by the resolution deadline, the contract provides for automatic termination. And that's what this says. The contract terminates. Or if there is resolution by the resolution deadline, then the contract continues. So anyway, just kind of a flow chart of how the inspection process works. I think the Forms Committee liked the idea, and maybe we'll stick this in the library. I think it may be beneficial for consumers to see it in a different form. All those words on a paper, they're not fun to read, and maybe this is a little bit better. I do want to point out that sellers cannot terminate based on a buyer's request for cure. So that seems to be, sometimes sellers think that, okay, you asked me to do all these things. I don't want to do them. I'm terminating the contract. Seller never has a right to do that. All the seller can say is no, and no, and no, and no, and no, right? That's all the seller can say. So they send it back and they say no. And then the buyer comes back with another set of objections because we're still within that period. And all the seller can say is no. That's all I can say is no. I never have an option as a seller to terminate based on the request. Now, if we don't have any resolution by the resolution deadline, it's going to automatically terminate, right? Right. So, and I will remind the buyers on the buyer side of this, if you're coming up on the termination deadline, the resolution deadline, and you're going back with the sellers back and forth and you can't come to an agreement, then if you don't want the contract to terminate, then you're going to have to pull all of those objections off the table. You're going to have to say, we'll take the property as is. You don't need to do anything. That will keep it from terminating because there's nothing to resolve because the buyer hasn't made any objections at that point. They pulled everything off the table. So keep that in mind and to keep it from terminating. Seller's property disclosure statement 2301. The big change here, guys. Our property disclosure statement. First of all, let me give a shout out to our Forms Committee and more specifically our subcommittee who worked on this. Jen Cody from Albuquerque, she was heading this up, and boy, did they work hard trying to figure out how to approach this very difficult issue. Our property disclosure statement right now is a wonderful statement for buyers. It gives them so much information, great information, right? And at their fingertips if a seller will provide it. Wonderful. Not such a great form for sellers. First of all, it's requiring them to remember things, lots and lots and lots of things, because it goes on and on and on. But what I've talked about before in the past, and what brokers in Santa Fe who deal with attorneys probably more than any other area of the state in the residential context, lots of attorneys get involved in residential transactions in Santa Fe. And if a seller takes that form to their attorney, the attorney is going to say, don't you dare fill that form out. Because it provides all sorts of information to the buyer. It has the seller committing to all sorts of information, right? Warranting certain things. And they're not just adverse material facts, guys. There's all sorts of things in there that they're disclosing that they have no obligation under the law to disclose. And yet the fact they disclose it can create liability. I like to joke about the lawsuit that was filed because in the seller disclosure statement, the seller said they had wood floors. And it turns out they weren't real wood floors. They weren't the kind that you could go in and resand, the real traditional wood floors. They were a laminate of some sort. And so the buyer thought they could refinish them, and you can't refinish a laminate. And when they found out that, they took issue with the seller and felt like the seller had duped them, had misrepresented to them in saying that they had wood floors. Did the seller have to tell the buyer that they had wood floors? Absolutely not. There was no place in the law that says you have to disclose you have wood floors, right? But the seller did it. They did it somewhere in the property disclosure statement. I don't think we even asked if they had wood floors, but somewhere in there they did that. And as a result of that, it set them up for a lawsuit that they, for disclosing something they didn't have to disclose. So we took a totally different approach to this thing. And we took a step back and said, okay, we've had this form that's been very beneficial to the buyer, but very onerous on the seller. And we need to level this playing field. And how do we do that? Well, what is required of the seller? Well, the contract is clear that the seller has to disclose adverse material facts, bad things about the property, right? That's absolutely required by the contract. And so let's approach the seller disclosure from that perspective. And so that's what we've done here. Okay. So the first page has a seller representation section. It reiterates again to the buyer that buyer, you have a duty to do your own due diligence, right? It then asks a couple questions: seller's use of the property, or has it been occupied? Has it been rented out? Give us some information just about, how this property has been used. And then it gets into all of these major components: roof, foundation, electrical, solar, heating, all of these things, plumbing. And it doesn't ask for a bunch of specifics about the roof or a bunch of specifics about the foundation or the plumbing. It asks for the seller to disclose adverse material facts. Adverse material facts. And we do define adverse material facts. And adverse material facts, I'm trying to find where I defined it. It is defined here somewhere. An adverse material fact is a fact that would impact a reasonable person's decision to purchase the house or what they're going to pay for the house. And I know that seems rather broad and rather generic, but that reasonable person standard is very common in the law, right? So we're not talking about, just somebody, the person who anything you tell them is wrong with the house is going to impact their decision. We're talking about a reasonable person. And so that's kind of that is the approach to this form is, is there something going on the roof that if, you can even use yourself if you're a reasonable person, that a reasonable person would want to know is going on, because it may impact my decision to purchase this property or how much I'm willing to pay for this property. That's what has to be filled in here, guys. That's what these blank lines are for. What is going on with the house that could impact the buyer's decision to buy or how much they're willing to pay for it? So you'll notice there's not a bunch of details about what kind of this or what kind of that. It just asks for the adverse material facts. And that goes on for 2 pages. That's the third page. Then it asks just a few questions on specific questions regarding mold, radon, HOAs, condo associations. And then there's a checkboxes here. Seller has knowledge of the following items or conditions. Yes or yes. Destructive insects, their common walls, encroachments. Do you know about any of these things? Check any that apply. If it's not checked, it doesn't apply. They don't have knowledge. They don't have knowledge. It doesn't mean it doesn't apply. So I take a step back. It means that the seller doesn't have knowledge. And then we finish it up. So I think it's 6 pages now. I think that's what it is. There is also an accompanying seller disclosure form a little bit similar to this. to deal with a couple of subparts, like for example, pools and spas. So that in the event, we're trying to solicit specific information about adverse material facts related to the pool or spa, there's another seller disclosure statement that you can attach to this that addresses those specific issues. So anyway, our approach to seller disclosure statements is completely different than it's been, guys. It's a whole new approach. And the form that now exists in the library, the Forms Committee has decided to pull it out of the library. So it's not going to be available. And as a listing broker on the listing side of a transaction, that this is good for your sellers. It's a good thing. And I understand that in a market where perhaps the seller is more desperate to sell their property than we're having right now, because I know there's multiple bidding situations going on all over the place right now. But, in another kind of market, maybe a seller is willing to provide so much more information, anything that, they need to provide to make a buyer feel warm and fuzzy about buying their property. And they're willing to fill out something much more extensive. But that's for, a separate conversation, and the seller can always fill something out that explains additional things about the property. But that's not what we're requiring as an association. We're not setting sellers up for, potential lawsuits by disclosing things they're not required to disclose. So anyway, whole new approach to the way we do that. Okay, hotline topics. Let's just run through these kind of quickly. We've got about, I think about 15 minutes left. GRT and referral fees. I mentioned this before, you guys. Tax and Rev looks at a referral fee that's not paid out of closing as a separate transaction. That means that if that money all comes to you, for example, as a listing broker or as a buyer's broker, and you have to share some of that with another broker as a referral fee, that has to be taxed again. Now, we all know we didn't collect 2 taxes on it. We only collected 1 tax on it, right? It was dispersed at the closing table. You got your buyer broker commission. You got your tax, your GRT on your buyer broker commission. Now you need to pay your referral fee over to this other broker. That's considered a separate transaction by Tax and Rev, if that's the way it's being handled. And it has to be taxed again. So what does that mean? Either you're going to be paying the additional tax or the broker on the other side is going to be backing that out. And that depends on the referral fee agreement. I think that our referral fee agreement, as I recall, actually provides for a referral fee plus GRT, but don't quote me on that. I don't have it in front of me right now. But whatever that referral agreement says is what has to happen. If you're obligated to pay the referral fee plus the GRT on it, or when you're just paying the referral fee, and now this broker over here who received it is going to have to back that out. How do you avoid that? Well, I'm not guaranteeing this is an avoidance of it, but what seems to be the crux for Tax and Rev is the disbursement of the funds. So if these funds are dispersed at closing, so in other words, at closing, you've got this one pot of money that's coming in with GRT on the totality of it, and then it's being divided between the listing broker, the buyer's broker, and this other broker who gets a referral fee out of one of those other commissions, and that GRT is all being disseminated at that time, that appears to be a way to avoid it, because what their focus seems to be is on the fact that this is now a separate transaction. So keep that in mind when you're dealing with referral fees. Okay, so info sheets, I just want to say, info sheets aren't required, guys. You might have a brokerage policy that talks about info sheets, and your brokerage might say, I want to get an info sheet on everything and every transaction. But that doesn't mean you can require the other side of the transaction to have their buyers and sellers signing off on all those info sheets. Okay, because it might not be their policy to get all those things signed. So you can present them and you can ask the other side, hey, would you please have your seller or buyer do this? But that buyer or seller has no obligation. Well, no buyers or sellers have any obligation to ever sign info sheets. But my point being is that they can't, because they're not required. For example, if you have a brokerage that has a policy that says, we want you to make an attempt to get all these info sheets initialed, and you can't get them initialed, they can't hold your check, or they can't keep you from getting paid because you don't have all those information sheets in the file. You can't obviously make buyers and sellers sign those information sheets, number one. And number two, the other side of the transaction, if they're willing to accommodate, they're willing to accommodate, but they might not have that same policy that they have to present all of these. The other thing I want to say about information sheets is that, guys, think about what applies to the transaction. Don't just be sending, I think somebody told me the other day how many information sheets we have in our library. I don't remember what the number was, 35 maybe? Don't be sending every information sheet we have in our library when maybe half of them don't even apply to the transaction in any way, shape, or form, right? I mean, just that doesn't make any sense. I was talking to a broker the other day about creating a form that lists all of the information sheets and has the buyer asking for the ones that sound interesting to them or the ones that they want. Now, obviously, if they don't, maybe they need one that they don't even know they need, and that maybe is where you come into play. But they can waive receipt of certain of information sheets, and they can request to get certain information sheets. So that's an idea that I'm going to take to the committee. We're going to take to committee, and the brilliant broker who came up with that. And then we could maybe have a conversation about, whether or not we want to have the consumers kind of more proactive as to what forms or what sheets we're providing. FIRPTA and QSS. I'm afraid that the wheels have come off this bus, you guys. I am hearing so much from around the state about how title companies are not providing qualified substitute statements at closing. And it's so disturbing to me because when the law changed to allow for qualified substitutes, I was just thankful that was the case. And we put this committee together, this task force made up of Land and Title Association people, and everybody was on board to provide them because the title company already has the tax ID information for the seller. So it made complete sense that you as a seller or you as a listing broker would, you as a listing broker would provide a non-foreign seller affidavit to the seller. They would complete that form or the title company's form and give it to the title company directly. So you as the broker don't even have that tax identification information on hand. And then the title company would give you the buyer's broker a QSS, a qualified substitute statement at closing. And the buyer would get a copy and the buyer's broker would get a copy. It seemed like it was all working so well. And then I just hearing all around the state that all of a sudden title companies and not title companies, sorry, there's a typo, not title companies, title companies are not providing this QSS anymore. And then I have to get on the phone and I have to have a conversation with their manager or their attorney. And I have to say, okay, what's the problem with this? And we usually come to an agreement and they get back on board again. But this is huge, you guys. This is huge because if the IRS ever comes to your buyer on the buyer side and ask why they didn't withhold money, then they need that QSS to explain why they didn't hold money. That's what they need in their file. So you as a buyer's broker need to be making sure you're getting these at closing. And if you're running into title companies that aren't giving them to you, which I'm afraid is happening, then I'm going to have to get involved and have a conversation. I know some of the bigger title companies are even having issues these days. So I'm going to have to engage and have a conversation and see if we can get those wheels back on the bus, so to speak, because it's really important. You will recall that our contract provides that if they don't get a QSS at closing, a non-foreign seller affidavit complete, because one without a social security number or a tax ID number means nothing. It's worth nothing. So if they don't get a completed non-foreign seller affidavit or a QSS at closing, the money is going to be withheld. Money is going to be withheld from that contract, from that money that's supposed to go back over to the sellers. The seller's not going to get all their money. That's what the contract says is going to happen. I know that's not happening. I know that nobody's doing that, but that's what's provided for, because otherwise, like I said, the IRS ever comes knocking on the buyer's door and they don't have that QSS or a completed non-foreign seller affidavit, they're going to want their money and the buyer's going to be responsible for paying that money, the taxes for the seller. All right. So I'm probably going to have to get involved in this. If you guys are hearing this around the state, if it is happening as much as I think it might be happening, it's not a one-off here and a one-off there. I might have to engage the land and title folks into the discussion again. We might have to kind of go back to the drawing board on it. I just want to give you a quick RICE update. This, and I'm running out of time, but this talks all about the extended period. Okay, so first of all, you can only have insurance with RICE if you're an active broker, okay? If you go inactive, you're covered for your activities when you were active. If you get a claim during the rest of the time that you've already paid your dues. So in other words, if you're active and you go inactive in the middle of the year, you've paid for the whole year. You get a claim towards the end of the year when you're inactive. Over something that happened when you were active, you're going to have coverage for that year. You've paid for the whole year. You're not going to have coverage for things that you did when you were inactive, but you'll still have that coverage for the stuff you did when you were active. So that's what the RICE policy says. But if you decide to go inactive, I always encourage everybody to get a tail policy, right? So you need some coverage after you're no longer practicing real estate, because what happens is you have to have continued coverage from the time of the claim to the time, for the time of the incident that the claim created, up to the time that they make the claim. This whole entire period you have to be covered, okay? The whole period. So it used to be you could only buy it through Rice for a limited period of time, and they've extended that. It's still limited, but it's now extended. It used to be just for 3 years. You can now get, and I know it's a premium, guys. I know that's not a fun number. That 300% of expiring premium is not a fun number, but it's highlighted because they now offer 5 years of extended reporting time opposed to 3. And why is that relevant? Statute of limitations. I'm not generally speaking for a negligent claim that you would incur, negligent in the way you conducted business is 3 years. A breach of contract is typically 6 years. So the more coverage you can get, the better. I recommend it minimum 3. And if you can do 5, you should do 5 if you can. I just want to point out that we've removed a couple of hold harmless agreements, our COVID hold harmless agreements. We had so many and it was very confusing. Which ones do I use? The 1508, which is the one way over here. That is a hold harmless that still remains in the library. And the way that hold harmless works is anybody who signs it is holding anybody else who signs it harmless, right? So if you have buyers and sellers both signing that form, you have to have at least 2 parties signing the form. And whoever's signing the form is holding the other harmless. So buyers and sellers, if brokers, you want to jump in there, then they're holding you harmless and you're holding them harmless. You want to throw a vendor in there, then that vendor's holding everybody harmless and everybody's holding the vendor harmless. So everybody who signs it is holding everybody else harmless. The others are going away. This 1506 and this 1501, I think they already have actually. The ORW, I just want to say that it's being revamped completely this year. Well, it's being revamped. I don't know how completely, but we are revisiting that form. But I did want to say, because this question comes up all the time, what do I do when a seller marks 1 or 2 in this section C? There's nowhere for the buyer to accept. How can they accept, you guys? There's no place for them to say what they're going to do. It says they're going to do a price reduction, but how much? They're going to do a seller concession, but how much? You can't agree to something if you don't know the dollar amount, right? So what we expect to happen here is you can mark that box, but then you abandon the ORW, you jump over to 2101, which is the price modification, seller concession addendum or amendment, excuse me, and you fill that out and you send it back over with your ORW. So sellers mark C1 and you're sending over the NMAR 2101. And what happens if the buyer looks at that 2101 and says, no, that's not enough, I want more? Then they can shred it. They can shred the 2101 created by the seller. They can create their own 2101. They can send that back over. And that just keeps going back and forth like that until you guys come to an agreement. Maybe you don't shred it. Maybe you put it in your file and say, that they declined it. But the way, you don't have to do anything else with it. You don't counter it. You just create your own 2101, send it back over with the number that your buyer wants. And then the seller either accepts that or creates another 2101 and sends it back over. And you just keep doing it until you come with a 2101 that everybody agrees to. Okay. And I was going to give you, this is the history of it. If you're interested, how we ended up in a position where we abandoned the ORW in that scenario. This is the explanation for that. If you are doing a price reduction or a seller concession, you got to amend the contract, guys. There's no way around that. And that amendment has to go to the lender. So this kind of explains it in more detail. This is a whole section, guys, that I obviously do not have time to talk about in great detail, but I just do want to mention it. Okay. I've had so many issues on the hotline lately, brokers leaving the brokerage and what happens, right? So first of all, I just want to say your independent contractor agreements, tying into the beginning of this presentation, you have to have those when you start working, and it should address these things. It has to address what happens when I leave, what happens to my listings, what happens to my buyer broker agreements, what happens to my, what happens to these transactions when I leave. It has to be addressed in the independent contract agreement or elsewhere. Because at the end of the day, guys, if contracts belong to the brokerage. So that means listing agreements and buyer broker agreements belong to the brokerage. So they stay unless there's some provision to the contrary. I also want to remind you about your fiduciary duties. And I do mean fiduciary duties because you are an agent of your QB as an associate broker. You are an agent of your QB and you have duties, including the duty of loyalty, which means that If you're deciding to leave an office, you have the ability to enter into a listing agreement. Maybe you have an ability to terminate that listing agreement. But if you're leaving and you want to take your people with you, and so you go over right before you do that and you say, hey, I'm leaving the office, sign this termination agreement so you can come with me to the new office. You guys, that's a breach of your duties. Okay. That very well. If you haven't had a conversation with your QB and your brokerage, or there's not a provision in your independent contractor agreement for how you handle those listings in that scenario. If you're just terminating them willy-nilly to take them over with you, then that's arguably a breach of your broker duties. We have the acknowledgement of transfer of purchase agreement that I talked about. If you have listing or buyer broker agreements, those are contracts. So those have to figure out what you're doing with those. And then if they are going with you to the new brokerage, then you can use the assignment of contract form 2103 for that. If you have pending transactions where you're representing buyers, but you don't have any buyer broker agreements, those buyers have no obligation to stay with the brokerage, right? There's no contractual obligation. So they can move with you over to the new brokerage. But guess what? Who's getting paid? The original brokerage is going to get paid the co-op broker commission if it's an MLS listing, or if there's an offer of compensation, a broker to broker compensation agreement in place, they're going to get that, right? So you got to figure out what's going to happen. What's going to happen with that commission? Is that original brokerage going to share it? And then you also want to draw a line in the sand for when is that original brokerage responsible for this transaction, and when do we become responsible as the new brokerage? I did a whole article on this for the NMAR Voice this month, and it's coming out next week. If you aren't getting those, make sure you get those. They come from NMAR. It's the NMAR Voice, and there's a section in there from my legal section is in there, and I'm always writing about something that's relevant to you guys. So make sure that you are looking at those and reading those, and this is all covered in detail in that. I will want to say that if you change brokerages and you take a pending purchase agreement with you because the broker wants, the buyer wants to go and they have no obligation to stay and they're going with you, make sure you notify everybody. You're now with a new brokerage, but you don't have to change the purchase agreement. You guys have to remember that the cover pages are not part of the purchase agreement, right? So you don't have to amend the purchase agreement when you're doing that. You have to notify everybody, but you don't have to amend the purchase agreement. Number two, I want to say that once you leave as an associate broker, you leave the brokerage and you're working for a new brokerage under a new QB, you can no longer do work for the QB over there. You can't move to the new brokerage and continue to work the transactions that you left behind at that old brokerage. They have to either come with you through negotiation with your QB or however that works, right? Or you have to stay there till they finish up. So those are just important things to know. Again, look at my NMAR Voice article. 3 points for key points for smooth transition when this happens. Preparation, communication, professionalism. The other thing, guys, you have to talk to your QBs before you're leaving and figure out how these are going to work. If you just walk out one day and decide you're going to another brokerage and you've got pending transactions and you've got people you're working with and you can no longer work with them because you moved to a new brokerage, what are they to do? They don't even know what's happening. You have to have these conversations with your QB ahead of time. Create a game plan, guys. Figure out how this is going to work and how everybody's going to be notified, all right? And be professional, because failure of you guys to communicate and be professional, of course, will impact the buyers and sellers, which of course can result in a complaint with the Real Estate Commission and the Code of Ethics. All right, state moratorium is still in effect on evictions. So for you property managers and people selling properties that are tenant occupied, be aware there is still a moratorium in effect. The CDC order, which has been extended to the end of January, ends the end of January, but we have no date on when it's going to sunset for here in New Mexico under our state moratorium that the Supreme Court has issued. So tenants who can't pay are staying in properties, and that's important for not only property managers, but for people trying to sell their property that have tenants in them. Couple of cases, you can read these. They weren't super exciting cases, well, unfortunately, or fortunately, I guess I should say. I'm glad people aren't suing. That's nice. But you can read these. That's the last of it. The hotline, that's my phone number, guys. If you guys have ever called the hotline, I am the attorney that answers the phone calls. I am the only attorney that answers the phone calls. We have over 6,000 members. So your patience with me is greatly appreciated. If you called me this week and I haven't gotten back with you, oh gosh, I'm so sorry. It's been a crazy week getting this together. And I will be back in touch with you this afternoon or tomorrow at the latest. And if I ever don't get back in touch with you within 48 hours, please do not hesitate to reach back out to me. So that's all I got for you today, guys. A lot of information in 3 hours. I greatly appreciate you all coming. coming. I'm just thankful that you took 3 hours out of your morning to meet with me and go over this stuff, important stuff. Call me on the hotline if you have questions. I have pages of questions. I'm obviously not going to get to them, guys. If you really want to know the answer to these, feel free to reach out to me on the hotline. Thank you very much. Have a wonderful 2021.